Hello, everybody. Hi. I've missed you guys like incredibly a lot. Ava, what the heck? If y'all didn't hear that, I think I'm gonna have to take the dog out very soon. She's already up here, but she's also in the air. Yes, aren't you, girl? So, I guess she missed you guys too. Yeah, she's just extra excited. Oh, I gotta do my hellos. Hi, Tammy. Shane, I missed you, love, very much. Trust me, it was no fun without you. Hi, crazy old lady. Emily. Hi, my sister. Hi, Brian Boggs. Thank you for my first like of the night. Catherine Gaston. And Ava is reporting for you. Oh, I'm glad I'm here. Still not 100%, but I'll get there. I'm sure. Takes a minute. And yeah, this caffeine-free, bean-free coffee, it just leaves something to be desired. What do y'all call this? Water needs beans. I can't tell which emoji that is. But I like it. No. I don't know what it is. All I can see is a little bit of yellow and some purple. Right now, I just need to get back to life, and the rest will sort itself out. That's how I function. You just push on through. Oh, no, it's not decaf, honey. It's caffeine free and bean free. So, yeah, in other words, it's just water. I don't do decaf coffee. No. Like the process that it takes to make decaf coffee, I don't trust it. When you have to add chemicals to start the removal of the caffeine and then add chemicals to make it safe to consume again, there's just too much in that. There's too much in that. It's just like eating the canned grapefruit. The way that they get the skin from in between each of the little wedges, they get it off with an acid bath, and then they have to put another chemical on to stop the acid bath, and I'm just not about that. I'll just get my grapefruit whole and eat it. Well, I would when I wasn't on blood pressure medicines that say don't do that. Yikes. Yeah, there's places around here that have like warnings in the public restrooms that say not to use the water without boiling it, like for bottles and stuff. Yeah, I don't go those places often. When I there was a place that I used to live with Kendra's father, and we would get every 6 months we'd get a water analysis report because it was previously an ammunition plant for the government, and then it at that time had barracks on it for soldiers, and then when they shut that down, then the barracks turned into condos. And we had a condo there. So me? Or in general? Did you forget your Discord login? You poor thing. Don't you have 2 already? Because of that? Am I thinking of someone else? Tea is good. Tea is good. Okay, I must be wrong. I can be wrong once in a while. It's allowed. If Palmyra Productions is allowed 5 a day, then I should be allowed at least 1. Yeah, there's when I have a really bad cough, there's a special tea concoction that I make. And it's I don't know if you'd call it tea, but I call it tea. But it's got lemon juice with so it's like a fresh squeezed lemon into water, and then honey and cayenne pepper, and then you stir it all up, and when it gets cooled down a little bit, you just guzzle it. And it really kicks the cough right out of you. Well, I do hope you're able to get into your Discord, because they keep doing movie nights over there. Hi, Tiana Miller, honey. Welcome. Yeah, they from my understanding, Emily and Tammy kept holding the fort down on the Discord with running movie nights while I was gone. I guess they were doing a Men in Black night in honor of Edgar, Edgar Lawyer. Yeah, it was funny. I saw him again today on a stream when I was downloading stuff, but I didn't clip that one. But I did. So the docket that the thumbnail is from is multiple hearings over multiple days. I was looking for something specific, and now I don't even remember what it was. But I was looking for something specific, and I was like, ooh, that's a good clip. Ooh, that's a good clip. Ooh, that's a good clip. Ooh, I like that one. So I ended up with, a whole docket that's not an actual docket, but it's still a docket. It's the same judge, and yeah, it's just multiple days and multiple hearings. Yes, and Phil appeals. Yes. He sings. He sings in them. Ooh, piece of candy. Ooh, piece of candy. Yes, that's exactly what it was like, Brian Boggs. You know what that reminds me of? Is there's a video of a little girl. There's probably thousands of them, but there's one specifically that's stuck in my head all these years. And she's holding a large cup of ice, and she's chewing on an ice cube, and she drops it. And so she bends over to pick it up, and one ice cube falls out of the cup onto the floor. And so she puts the one she's holding into the cup, and she bends over to pick up the one that fell out, and another one falls out of the cup. So she puts the one from the floor into the cup and bends over, and it just keeps going. The poor little girl. It just kept happening. I don't know how the mom kept filming without busting out laughing, because this went on for a long time. Yes. Hello, Catherine Gaston, my love. It has never been my friend. Hi, K.L. Burke. Hello. Yes. I've had many. And that's probably why that clip just resonates so deeply with my soul. Yep. Oh. What do you say, guys? Should I put a clip on? I have more than just that docket as well. I've got stuff that's fresh from today that I really enjoyed. Because rather than trying to, I did not even check any of my exclusives. Y'all, that is how gone I was today. I couldn't even get the energy to load my exclusives up. That's bad. That's saying something right there. So instead, since I wasn't running my exclusives while I was editing, I was running locals. Oh my gosh, a ghost has appeared. Tink! Hi, Tink! Tink, 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 tink. Hi, April. Good to see you, honey. Missed you. It's been a long time. I'm glad you're here, though. Tink says hi. Oh, let's see here. Do we start with Won't Shut Up with a Dispossessory, Something Wholesome, or the long docket? Well, I have 2 long dockets. If I were to stream everything that I have currently ready, I'd have to put my sleep mask on so that I get credit for the night. Just go chronological, says Brian Boggs. I don't want to do that. I'm gonna do this. Kind of go reverse chronological.
Black line, right? Face the camera. Say your full name.
Rodney Givian.
How do you pronounce your last name, sir?
Givian.
All right, thank you, sir. I'm Magistrate Chavez, sir. You're here on 2 criminal matters. One's a misdemeanor, one's a felony. The misdemeanor matter, case number is 240-4413601. You have an attorney. Go ahead, counsel.
Judge Kashaba, on behalf of Mr. Johnny, who has formal reading, understands his constitutional rights and stands view on both matters, Your Honor.
Well, then, both matters. And let's go with the second case also. Case number is 240-5539401. It's a felony. And okay, so
Your Honor, is that the?
on both matters, I'm going to enter plea of not guilty. Counsel Ragnan, we haven't gotten to that yet, please.
I'm
I
sorry.
appreciate it. That's all right. So let's see. On the misdemeanor matter, court date is March 12, 2024, pretrial in front of Judge Bryant. Sir, on the criminal matter, court dates are January 31st, 2024, probable cause conference, followed by preliminary examination, February 6, 2024. Both matters, those 2 court dates are in front of Judge King. So March 12th is in front of Judge Bryant. The other 2 court dates are in front of Judge King. Let's see. Okay. All right, it involves the same individual. So let's start off with, all right, on both matters, you are not to have contact with a Tiffany Dudley. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Do you understand that, sir?
Yes, ma'am.
All right. You're not to possess any firearms or any other dangerous weapons. Do you understand that?
Yes, ma'am.
See what else?
Your Honor, I'll wait. Sorry.
Okay, thank you. You are not to go to her location, city of Detroit. Do you understand that?
Yes.
Okay.
Looks like him, and it should be.
That is on both files, sir.
Yes, ma'am.
You understand that? Okay. Make sure. Counsel Ragnan, you're here for the people. Go ahead, Esteban, sir.
Your Honor, first I'd like to ask you to add to the no contact list the complainant's daughter, who has texted many times and threatened to kill her. She's a 13-year-old daughter. And I please would ask him to include that as well.
Okay, and
What date are we
Let's see.
spending? Which complaint, Your Honor? The
I'm looking to
11724?
see, excuse me, I'm looking to see what's the name of the daughter.
Oh, let's see. It's,
Do you have that?
believe I do. Just a second. Tiana Dudley.
Yana, you know how to spell it?
Teanna, and then Dudley, Dudley.
Okay. All right. So, Ms. Givian, sir, while this case is pending, on both cases, you are not to have with the Tiana Dudley. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Do you understand that, sir?
Yes, ma'am.
Okay. So with that being said, Counsel Ragnan, go ahead. Thank you for that information.
Yeah,
Go ahead,
people are
Esteban,
asking
please.
$50,000 cash surety bond. If he's able to post the bond, we're asking for GPS tether with home arrest. This is a person who has put the complainant and her daughter through living hell for a year. The police have said that there was an average of 100 calls a day made by this man, texting her, threatening to kill her, sending messages to the complainant's cousin, say, you don't have to worry, I'm gonna kill her today. Today is the day. I'm gonna get the dog and that hoe. I'm gonna kill them. I don't know why he thinks this is funny, but this is what this man has done to this person. I don't know why he's laughing. He said it's happening tonight. The complainant perceived these messages that he was going to kill her that night.
And the dog?
She got a personal protection order served on him on 1/16/24. But on 1/17/24, he's calling her on the phone, telling her how he's going to kill her that night and so on, and come on outside and tell your dog to come outside as well.
Oh,
All of a sudden, there's banging on the
Ask you,
door.
Council Ragnan,
Why is
Council
20?
Ragnan, I'm gonna ask you. You said he was served with a PPO. When?
1/16/2024.
Does a PPO indicate that he's not to have contact with the complainant?
That's what the PPO was for, yeah.
Okay, and so on the 17th, there's the allegation that he has contact with the complainant?
Well, sure, he's calling her a number of times. He's banging on the door. The man that was in the house looked out the peephole of the door and identified him, and he said he saw him with a gun that he put behind his back. He described the gun as well. So when there's so much information, Your Honor, but I'm just trying to give you pieces of it. In one interview
Excuse me, Your Honor.
particularly, they're talking to the complainant. He called 18 times. Well,
That's you, sir. Okay, Mr. Giveon, put your hand down. You have attorney to represent you. Go ahead, Council Ragnan.
Well, the police was interviewing the complainant on one occasion. He called 18 times and then put him on speaker with the police listening. And the police heard him threatening to kill her and go on. Another time when the police came out to the house, he called back. She put it on and she had blocked the phone, but he keeps getting numbers off apps or some way, block numbers. So he kept calling. She answered the phone with the police sitting there. It's all recorded by them that in fact he is threatening to kill her and her child. Your Honor,
Thank you.
it just goes on.
Okay.
And
I got that. I got everything that you're telling me. Now, what I need to know, and this is from DDC.
Yes, Your Honor. Yes, Your Honor.
Does Mr. Giveon, does he have a parole detainer or is he on
Mhm.
parole?
Yes, Your Honor. Parole detainer. A firm.
Thank you. Okay.
Yes.
they absconded on 11/26/23, Your Honor, from the.
Excuse
you.
me, Your Honor, that's a lie. I'm not absconded.
Your
That's a
Honor,
lie.
and I need to say one more point at least, that when he was interviewed, could you ask him to put his hand down and quit making gestures
Okay.
towards us here? Your Honor,
Excuse me, Your
he
Honor.
admitted in an interview that I sent her text messages, I sent her emails, I called her numerous times. He admitted he did all that. So, Your
Council
Honor,
Ragnan, thank you for all that information. Okay, however, okay, he's on a parole detainer. So there's gonna be a monetary bond, whether I like it or not, because he has a parole detainer. And then if I gave him some sort of monetary bond, at least he's gonna get credit. Well, because of the parole detainer. What was the
Well,
bond
Your
amount
Honor,
you were asking for?
I was asking for $50,000 cash surety, if he's able to post bond GPS tether with home arrest, Your Honor, on both cases.
Council, Scheid, please talk to your client, counsel.
Sir, this is your attorney speaking. Anything you say right now can and will be used against you. It's not that we don't want to give you a chance to speak. I want to advise you to not speak actually, because the prosecutors are on, we're on YouTube, it's live on YouTube. So anything you say right now can and will be used against you.
Yeah, I would
So I
like to
don't
speak
pay to
though.
volunteer any information.
I would like to speak though.
Okay, I'm just gonna advise you again that as your attorney, I'm gonna tell you to exercise your right to remain silent, because anything you say right now can and will be used against you.
I understand that, but excuse me.
Mr.
The thing,
Robinson, please
No.
listen to me. Listen to your attorney. Don't say anything. The reason you shouldn't say anything, everything is being recorded. Whatever you say, whatever gestures you make, all of that's being recorded, and it can be used all against you in this case. Do you understand that?
I understand that, and I would like to waive that right so I could please speak, because the things he just brought up to y'all was recanted by Tiffany Dudley, by the detective, and he know that. Everything he just
All
said
right.
was recanted by
Okay.
Tiffany Dudley.
All right, Mr. Vivian, okay, all that information, that is something that you should talk to your attorney about, so that when you go to your probable cause conference, when you go to your preliminary examination and all other court hearings, that information goes to your attorney, so your attorney can prepare, okay, how you and him are going to prepare for this case. Do you understand that?
Yes, ma'am.
Okay, now, Counsel Shive, can you
Yes, Your
tell
Honor.
me what he's on parole for?
Is that going to stop him, even though he says he understands that? Is that going to be his only outburst? Oh, shoot. I just hit the button.
Just Sheva,
That's what the PPO was for, yeah.
Hold on. I'm sorry.
Ma'am.
Okay, now, Counsel Shive, can you
Yes, Your
tell
Honor.
me what he's on parole for?
1 second, Your Honor.
I have that, Your Honor. That's okay with Ms. Shive. He's on parole for assault with intent to rob while armed and felony firearm.
Okay,
Excuse me, can you tell that was in 2008? I haven't been in no trouble since 2008.
Prison.
Well, you sure made a heck of an entrance for not being in trouble since 2008, my friend.
If I went over her house with a firearm, I would have a firearm violation.
don't say anything, because everything is being recorded. Yeah. Counsel Shive,
Yes, Your Honor.
okay, are you ready, finished? Are you ready to proceed?
Can I make a bond argument, Your Honor?
Oh, yes, ma'am, that's what I'm waiting for.
Okay, yes. So he is, he has one child, he's a lifelong resident. I'm not aware of KP's history, Your Honor. He understands the no contact. According to my client, the complaining witness, has taken back the statements and doesn't want to proceed, but that is the knowledge I have from my client, Your Honor. I'm respectfully asking the court to consider a personal bond, no objection to a high personal bond. I know that the court is saying that he has a parole detainer and so is DDC, but according to our client, there has been nothing in 15 years that he is on top of everything. So I'm respectfully asking the court to consider that personal bond and to not give the tether. But if the court, Your Honor, can only do a personal bond with the tether, then we understand that, Your Honor.
Oh, well, thank you for understanding that we don't want this crazy guy who's threatening to kill people while cops can hear, that we don't want him just running out willy-nilly in the neighborhood. Oh my gosh, a personal bond for real.
I've heard the
Yeah.
representations of both sides. I don't need to hear from anybody else. In this particular matter, my understanding is that Mr. Givian is on parole, and whether he's on parole for 5 years, for 10 years, he's still on parole, okay? In this matter, I did look under Court Rule 6.106. This is not listed as a violent felony, okay? So, violent felony also, while he is committed at the time that he is on parole. So that I can't do. However, misdemeanor was November 25th, 2023. The felony was January 17, 2024. He will serve with a personal protection order January 16, 2024, meaning he's not supposed to have contact. But allegedly he did. So in this particular matter, for both matters, okay, he's going to get bond of $50,000 cash. No surety, no 10%. I will leave the issue as to GPS tether and any other conditions in terms of the GPS tether up to Judge McConicle, because he's on parole. Okay, appears he's going to have an unaffordable court bond redetermination hearing. Is that correct, Council Scheib?
So on this court
Yes,
date,
Your Honor.
Okay, so that means, and Mr. Robbins, excuse me, Mr. Jivian, sir, you are going to have a court date this Friday, January 26, 2024, 9 o'clock in front of Judge McConicle, who's going to look at the bond amount and bond conditions. Do you understand that, sir?
but excuse me, now can I ask you, when I have a court date to charge so I can get my charges dismissed?
Well, that will be,
Because-
sir, listen to me. You got, your next court date is this Friday, that in terms of your bond conditions. And then your next court date will be on March 12th. That's in front of Judge Bryant. But on the felony, January 31st. That'll be a week from today.
So and that January 31st is court date for what?
And that is a probable cause hearing for the
So
aggravated
so-
stalking and
so-
habitual
so for
third
the
offense
aggravated-
notice.
All right, so thank you. So for the aggravated stalking, if Tiffany Dudley don't come like she not, because she already recanted her statement, you know that.
Sir,
It will be
I,
Now, Mr. Jivian, let me say this. Whether she retracts it or not, that's not up, she can retract it or not. But as to the charges, that is up to the prosecutor's office. It's the prosecutor's office is whether or not they want to dismiss charges or not, or if they want to go forward.
All right, thank you.
Thank you, Mr. Jivian. You can step aside.
Your Honor, one bond was 50,000. What was the other bond?
Bond is $50,000 on each, $50,000 cash on both.
Thank you.
Thank you, Anna.
Thank you.
Ms. Scheib.
Now let me write all this stuff down.
Say your full name?
Kyle Graham, Your Honor.
Stand by, sir. I have to fill out the prior case.
Yes, ma'am.
Thank you for your patience.
Yeah, I left just that little spot in the beginning there of the next guy to show, like, she put everything on hold and she was filling out paperwork on that guy for a good 3 minutes. It was crazy. Oh my gosh. And yes, Sissy Rusk, thank you so much. I'm so happy to know that that it's the afternoon there for you. That's crazy to me because it's midnight here. Stephanie, thank you so much. I love you. Thank you. I appreciate so much what you did for me. Truly, absolutely. Oh. I told him I'm going to appreciate my paperclip forever. And he's making me come on early. So I will have something ready. I can't guarantee it'll be anything good. Because I have to come on early. Thank you very, very much for the super chat, Palmyra Productions. We haggled and we settled on only an hour early. Everybody loves you. They love all the boxes. See, Palmyra Productions has a rule that absolutely no company money can be spent on the cats. If it's on the dog, he's okay with it. But no company money can be spent on the cats. But yet, every time he sends me something, the cats get the boxes and they love them. And that makes me happy. Yeah, see? So, Palmyra Productions has made my cats the happiest kitties around. I'm okay with that. I'm just happy you're here, finally. She made quite the entrance when I started the stream. Yep. She got so excited she sat next to me and tooted. Just for you. Yeah, see? My chat knows me. They know. I am just as excited over a stinking box. Man, I could build a fort. No, I'm not joking. I'm not joking. Yeah, right. They would be the ones. They would be the ones. Is that what I keep all those little pouches full of air that I keep popping? People are actually buying those? But it's my fort. I'm going to get a whole bunch of bankers boxes and I'm going to line my, I'm going to create a border of bankers boxes. Well, that's all I got. Good night. No, I'm just No. I've got more. Oh, this was fun.
Announcement on your case.
Your Honor, that broke down rather quickly.
Oh, you think?
I need to know from the clerk whether or not service was perfected, tacky mail, personal, whatever it was, because the defendant's claiming she wasn't served.
Okay. Ms. Harper, if you could check on that for me, I'm going to go ahead and take up position number, I think it's number 6, Nancy Jones versus Sean Redden.
Thank you,
Does
Your
anybody
Honor.
else need their breakout room link? There's a couple folks in here that have report. Oh, that was position number 1. Okay. All right, folks. So Ms. Ivory Johnson, I'm going to put you back on mute while we're waiting. All right. So let's see. So Mangrum.
That's correct, Your Honor.
Okay. So it looks like I did look at this case earlier. It's on Mr. Redden filed a motion to open the default stating that he had not been properly served. So I'm assuming that's why the marshal is here to testify about that. We can go ahead. I've read the file. I think it's a holding over dispossessory and okay. All right. Holding over. Mr. Redden is saying that he did not get service. And so I guess I'm ready to go forward. Now.
Okay.
All right.
At this time, I would just call Deputy Marshal Mack.
Okay.
Hello.
Hi, Ms.
Hey.
Mack.
Would you like for me to swear her in, Judge?
Yes, please.
Would you raise your right hand? You swear to tell the truth, nothing but the truth, under penalty of perjury?
I do.
Thank you. Ms. Mack, are you familiar with this case 23D33658?
Yes, I am.
Okay, and are you the marshal that affected service in this case?
Yes, I was.
Right, and was there tack and mail? In other words, was a copy of the dispossessory warrant, affidavit, and summons, as well as, well, was that tacked to the door, the dispossessory warrant?
Yes, sir, it was.
And was that of Tucker, Georgia, 30084?
Yes, it was, sir.
And was a copy sent out first class mail?
Same day.
Okay, and that date was December 26th of 2023, according to your affidavit. Is that correct, Deputy Marshal?
Yes, sir. Yes, sir.
Your Honor, it would appear that we have valid service in this case. The defendant's answer was late filed. There is no opening of default in magistrate court dispossessory actions. Therefore, Your Honor, we just move for the issuance of a writ of possession in Stanner.
Okay.
We're
Is there-
not seeking a money judgment.
Okay, it looks like, has a writ been signed already? Let me look at the writ real quick. Okay, it's not been signed yet. Okay. All right, so Mr. Redden, we just heard testimony from Ms. Mack. I am going to give you, she's testified. If you have any questions, this is not your opportunity to testify or anything, but if you'd like to ask Ms. Mack some questions on cross-examination, this will be your opportunity to do that now. You're going to need to unmute yourself, sir.
Apologize, Your Honor.
All right, I'm going to ask you to raise your right hand.
Yes, ma'am.
You swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Okay. All right, I'm ready. You can, again, this is not your chance to testify. You can ask Ms. Mack whatever questions about her testimony that you have.
All right, Ms. Mack, was there any photographic evidence provided of it being tacked to the door? Because I only came home and found
This is questions. You get to
I'm
ask
sorry,
her questions,
I'm sorry.
but you're not testifying.
Was there any photo evidence of it actually being tacked to the door?
There is a actual video with it being tacked to the door at 08:57 hours.
Can you please present that? Can you please present the evidence if it's in existence? I would like to see it, please.
Right now I'm in the courtroom and I'm not at my actual truck, but I'm sure that my supervisor can provide that.
I understand, but I believe that should have been prepared already if this was coming up.
Again, questions, Mr. Redden, questions.
Yes, ma'am. Yes, ma'am. Yes, Your Honor. I apologize. Officer, was the letter placed into my mailbox at the same time that the order was tacked to the door?
No, it doesn't work that way. The way the service is perfected is tack and mailed to the door, and then the afternoon is actually sent out in the mail, certified mail.
Okay. So do you believe it was possible if it was filed later that I would have received it in the mail later than I was able to answer?
I'm not sure because both was presented on the same day.
Well, did you not
Unless
just
you
say,
wasn't home.
did you not just say that it was mailed later? You just said it was presented on the same day, but then just a moment ago you said that it was mailed afterwards.
No, that's not what I said. I said that the tack and mail was actually done that morning at 8:57 hours. And then it was also mailed the same day as soon as I came in at 11 o'clock because we have roll call at 11 o'clock.
Okay. Well, I would like to see the evidence of it tacked to the door because it was not there. I only received what was in the mail that it was, and when
Okay, again, Mr. Redden, questions?
I apologize, not questions. I didn't have
testimony.
questions. I apologize.
Okay.
No further questions, Your Honor.
Okay. All right, Mr. Mangrum, do you have any other evidence to present?
Not at this time, Your Honor. I don't find it necessary. I mean, if we're going to go forward on this case, then of course I would have some evidence to present. However, I think the law is clear, tack and mail service, and to answer within 7 days. My client's entitled to a writ.
Okay. All right. So Mr. Redden, this is going to be, if you want to make a if you want to testify, you can testify now. I think I pretty much understand what you're saying, though. You're saying that you did not receive the tact. We've got the deputy stating she tacked and mailed it on the same day, and you're saying you did not see it tacked on your door. I think I understand that that's what you're saying.
Correct. I actually have a couple other things I'd like to add, if you wouldn't mind, Your Honor.
Sure.
Okay, the moment that I received that letter in my mail, I contacted Mr. Mangrum saying that I received the letter and that I would be happy to answer promptly, and that was on a Friday. I went up on Monday, the court was closed, and then I immediately went up on Tuesday and went to answer. I did it as promptly as possible. Second, I believe this is a retaliatory eviction. I believe you heard my TPO case that was fraudulently filed by the other member of this house. Which was dismissed. I then filed my own TPO, which I immediately won due to overwhelming evidence of the abuse. And
Mr. Redden, you did not win that. It was dismissed because of the jurisdiction was wrong. You did not get a TPO. I've looked at it.
Ma'am, I actually have it right here if you'd like me to present it to you. I've actually submitted it under evidence as well. It was only dismissed incorrectly, and I received a letter from Cobb County saying it was incorrectly dismissed, and it is it is currently
in Cobb County. Okay.
It was
It doesn't really matter, honestly. Like I what I saw from the cases in DeKalb is that case that you filed was dismissed for lack of jurisdiction because
you are correct. And then I had to refile in Cobb, Your Honor. They got it.
Exactly. Okay, that makes sense. Okay, got it. Okay. All right. So, Mr. Redden, again, we are here on your motion to open default. We have an deputy here that has testified that she tacked and mailed it on your door, which is the legal requirement for these cases. Do you have anything else you want to add?
Yes, Your Honor. They also filed this eviction when I asked for repairs to be done on the house. I have fallen through the deck multiple times to the point I've been on crutches. I've cut my finger open multiple times. The ceiling is caving in. We have rats that I've had to kill dozens of. There are leaking lead pipes. There are mold. There are asbestos tiles on this property, all of which I have made multiple requests to get repaired, and they have been denied and have caused me multiple injuries over the years, which I've never filed suit until they have tried to retaliatorily evict me after their daughter threatened to kill me and shoot me and attacked me again.
Okay.
So why are you fighting so hard to stay in that place? Why wouldn't you just move out by choice? If I lived somewhere that had all of those problems, I would be getting the hell out of there. Not fighting to stay in there.
All right. Is there anything else?
No, Your Honor.
Okay. All right. Again, we are here today on the motion to open default. I feel that the Deputy Mack testified credibly that she tacked and mailed the service of the dispossessory properly. And so I am going to find that the default will not be opened and a writ of possession be available to the landlord or the plaintiff. And that concludes the hearing in this case. I will issue an order. Or Mr. Mangrum, do you want to present that order or do you want me to do it?
I'll be happy to email it to your clerk, Your Honor.
Okay. All right. And again, this is just possession only. There won't be any sort of money judgment associated with it. Again, it's just the default. A writ will be available. All right. You're all excused. Have a nice day.
Thank you, Your Honor.
Is there any chance for me to appeal, Your Honor?
You can consult an attorney about that, but yes, you can appeal.
All right. Thank you, Your Honor.
All right.
All right, take care.
Can I appeal having to move out of my rat-infested, ceiling-falling, mold, lead pipe, asbestos apartment, please? Sure. Oh, yeah, that guy was fun. Yeah. Hi, Earl. Yes, I'm glad to hear that your surgery went well. We are all so happy to have you back. Okay, this one is This one's so cute. It's short.
Shouldn't be a problem in Michigan.
Yeah, pulling a trailer. I don't think I'm going much more than 75.
Okay, we got Ms. Thomas. We'll bring her in.
Ooh, I didn't even get to that one. All right.
That's the only one we show is Ms.
Oh,
Thomas.
I had one for McCall. I'll figure it out as we go.
I see it too.
Good luck,
Oh,
sweetie.
that's the one that's here is Ms. McCall.
Okay.
Yeah.
Wow.
Oh,
that makes
that's why we've got a name Betty McCall, and on the waiting room it says Betty Thomas. Let me see if that's the same person, a maiden name or something. Unless I'm gonna mute. Okay, your screen name is Betty Thomas. Is that your name, ma'am?
Hello?
Is your name Betty McCall or Betty Thomas? What is your name, please?
I'm like, I think that's Betty McCall, I believe.
I don't think she can hear us.
Hmm.
I'm not muted. You can hear me and I can hear you.
Yep. I heard her speak. I just wonder if she doesn't have her speakers up.
Ma'am, can you hear us? We can hear you.
This reminds me of the early days of COVID. But everybody was learning how to do this.
This is mad.
Ma'am, can you hear us?
Mute.
Do you have the crash report? You might have her phone number in it.
I can grab. Let's see it.
Dirty.
You got it? Can you hear us now?
This up here.
Hello?
Can you hear us, ma'am? We can hear you.
Do I need to come see why it won't talk? Why it's not saying anything? It's on. I don't hear anything.
You got the speakers on?
All right, somebody's got it.
Let me see.
He's.
Here comes that. IT's got it.
If we can hear you, can you hear us?
See, I'm not muted. He is. He got, what does it say? Add. What does it say?
Let's say Floyd.
The meeting is being live streamed.
I love
Chat
them.
preview.
Oh,
You don't want that. Let's see.
Muted
Yeah.
means. Know what they say right there, where that number one written audience at the bottom.
we can hear you.
Chat,
Show chat preview, share screen.
go up there to chat and see what that red, what the red is right there. See what that says. Can I put a chat in there to ask them if the speaker?
If this works, I'm gonna be surprised if there is a chat thing.
Officers never heard of the chat function in Zoom.
He is on. I'll go back over there to my computer and see if I can get on that.
It's on. See the plug in.
Let's see what it says. You won't they don't say anything. But I
You
think
haven't stopped talking
she's
yet.
saying something.
You know what?
Get it on my phone.
Want to try this, please?
Of course, this is one time they're not looking at the screen. Well, I wonder if they could see us.
I think they could see us. I think they could because they were saying that we weren't saying anything.
Yeah, I'm trying to pull up. Oh,
If they look at the screen, I've chatted to them twice.
I've never used the chat. Oh, hey.
Chat's a
Yeah,
good.
I just learned something about it. I didn't even know the chat was here.
Okay, one closed up. Oh, jeez.
There's look at the screen now.
Ready?
Yeah. Hello?
Hello, can you hear us?
I got it.
Okay. Thank you.
All right, I think we're good now.
Okay, I'm sorry about that.
No, you were doing what you needed to do. And it's working now.
Yeah, okay.
What is your name, ma'am?
Betty J. McCall. And I'm married, so it's Thomas, but it's not official. Officially the McCall. I mean, I haven't transferred it over.
Okay.
Your Honor, on this one, I'm actually going to motion to dismiss the citation.
Okay.
Okay.
You said you're gonna dismiss it?
That's what he said.
I appreciate that.
Doesn't get better.
It sure doesn't. So what do I do now?
You need to do nothing. You're all set. Tickets
Oh.
dismissed.
Thank you so much. Oh my goodness. Thank you. Let me
You're
see.
welcome.
Now I'm gonna turn you off. Okay, let me see. How do I leave the meeting? All right.
That I can help you do.
Okay. All right.
She figured it out.
She's a-
What's your
Yeah,
total?
she's very, very nice lady, and she was in town.
I want to hear the story, officer. Come on. Oh my gosh, that was way more fun than it should have been. I just couldn't resist. Yeah, every once in a while, we get so much crazy that every once in a while we have to throw in something that is just hilarious and adorable. I love them. I hope I'm that darn cute when I'm that old. Oh, she absolutely had such a gorgeous smile, for sure. Yes. Oh, and he was so adorable. I loved him. And the whole group was so cute. The four of them need to hang out and have a couple coffees together outside of court. You know, it's just the perfect team. They could share stories and laughs, and yeah, I love them all. Oh, and now let's have some crazy. And it's gonna be a lot of crazy. Oh yeah, her husband was handsome. He reminds me of the guy that I'm always referring to as Backpack. I'm sure that's what Backpack will look like later in his later years.
Case number 2320965 CZ. It's the state treasurer for Michigan versus Katie Larson, inmate number 863470. We are here for the state's request to seize 90% of assets that the inmate has. The court has read Ms. Larson's response to the complaint. I've also received a brief from the state regarding this hearing. I've read that. And with that, Ms. Jones, you can go ahead.
Thank you, Your Honor. The state commenced this action after let's see, a check for $7,427.65 was deposited into Ms. Larson's prison account. Ms. Larson's earliest possible release date is July 17th of 2036. And through that date, her estimated cost of care is $758,630. Upon reviewing the case, we discovered Ms. Larson does have, I believe it's 3 minor children. And from the $7,427.65, there has already been $3,713.82 deducted and applied towards her child support obligation. And the only defenses to the State Correctional Facility Reimbursement Act is whether there is a legal or moral obligation to support a spouse or a minor children. So the state believes that her minor children have already been considered, as approximately half of the funds have already been attributed to them. So the state is going to seek 90% of the remaining $3,349.62.
Okay. Ms. Larson, is there anything that you want the court to know?
Well, I suffered blood clots in my lungs back in 2014 and 15, and I feel like I shouldn't have suffered that with I don't know, I didn't do this for just no reason. So really it feels like my pain and suffering was for no reason. And I just feel like that's not fair. And I'm not even asking for a lot, honestly. I just feel like just the minimal amount, just for what I had to go through all the time, and just the effort I put into this just for nothing. That's what it feels like. And I mean, I understand it's not cheap for the state to take care of me, but I also have to try to take care of me too. And costs these days just keep going up and up. So, I mean, I don't know. That's all I got.
Do you have a current ongoing child support obligation?
Well, not that I knew of until money got put in my account, but then yes, it should be paid off, I would think, by now, because my children have been adopted.
Okay. So it sounds like maybe there was some arrearages or something before that adoption took place. Then
Yes.
in front of the court came in, took $3,713 to square you up, so to speak, with the front of the court. Does that sound right?
Yes, sir.
Okay. To use for your own needs, correct?
Yeah, like hygiene and stuff like that.
So, Ms. Jones, are you asking the court, well, let me phrase it differently. How much are you proposing to leave for Ms. Larson in the account?
Your Honor, the state is requesting 90%. That would leave her approximately $330, give or take. The amount that I'm showing is as of December 11th. So if she spent something since then, the amount may be lower. That's the total value of the account. But as of December 11th, it was the $3,349.62.
Okay. All right, the court is going to side with the state in this case. And that the plaintiff will receive 90% of the funds in Ms. Larson's account as of today. Ms. Larson's can retain the 10%. Ms. Larson, if I could, I would let you have it all that was left. You know, it's one of those things, like you said, that it was a compensation for pain and suffering and so forth. Probably not nearly enough to compensate you for what you went through, but that's what you got. But unfortunately, the law doesn't allow me to do that. Those funds are considered an asset. And the law says, other than the kids, I got to give it to the state. So I wish the law was different. I wish people could keep, under certain circumstances, their personal injury settlements. But I can't, so I won't. So you just get the 10% of what's left. And Ms. Jones, you'll submit an order, is that correct?
Yes, Your Honor.
Anthony Overlook, case number 2313321, FH, he's here for sentencing. Prosecution and defense was the pre-sentence investigation report timely made available to you.
Was, Your Honor.
Yes, Your Honor.
And Ms. Frisbee, have you had the opportunity to read the report and discuss it with your client?
Yes, I have, Your Honor.
Do you have any additions, corrections, or challenges?
The only challenge I have is on the compass grid regarding vocational education. It says highly probable. I think that, you know, he's had some training. He's gone to school for welding and he had some other vocational training. So I think that's an incorrect assessment. Should be unlikely.
I'll leave it as is. Any
Otherwise,
other
I have no
additions,
other-
corrections, or challenges?
No other challenges.
Anything that you want to say on your client's behalf?
Your Honor, I know you've read the PSI. I just want to draw your attention to the fact that my client did, you know, admit to taking these classes from the from iCare1 in the report. He has been attending church regularly since he's been incarcerated, and he's just hoping for less than 18 months inside, but he does have 99 days credit, which we're asking for. Thank you.
Right, and Mr. Overlook, have you had the opportunity to read the report and discuss it with Ms. Frisbee?
Yes, I have.
Do you have any additions, corrections, or challenges? Anything that you want the court to consider? So tell me, Mr. Overlook, given your extensive records for theft, and particularly the number of felony retail frauds that you've had before, tell me why I should accept this plea agreement for no more than 18 months and that I shouldn't reject this plea agreement and send you to prison for 4 or 5 years.
All I can tell you is that my record is, I'm done with my activity. It's something really embarrassing to me at this point in my life, and I'm ready to move on from it.
Your Honor, when he says he's embarrassed, when I was going over this with him, he said, "I'm just embarrassed that you know, the things that you're saying are embarrassing me." I've never heard anyone say that to me before. So when he says was embarrassed because of this activity, he means it. And I mean, in his defense, yeah, of course, Your Honor, that, you know, he doesn't, all of his doesn't have any high severity felonies. They're all low severity, you know, retail fraud, just uttering and publishing, you know, that kind of stuff. No violence that I can see. All low severity felonies.
So why do you steal, Mr. Overlook?
Sorry?
Why do you steal?
Well, there's been a lot of different reasons. Earlier ones were mainly attributed to drug use. And then there's there's really no good answer I can give you for it. The money, drugs, time, honestly, I ask myself the same question all the time now. Since I've been in here for 3 months, I've asked myself that same question every day. My background, my mother was head of loss prevention for 30 years when I was something that should have been, obviously, she tried instilling in me that was wrong. Didn't take, I kept messing up, kept doing it. And finally, this has started becoming the end result for it. And it's gotta be done now.
All right.
Great
Mr.
grandpa
Stay, any
in the
additions,
house.
corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
People are asking that the court accept the plea agreement and sentence in accordance with that agreement. Some of the reason for the cap in this case is this somewhat unique set of circumstances. And there's, after speaking to the assistant prosecutor who ran the prelim, there are some challenges with presenting this case. So the people are asking that the court does accept that plea agreement and sentence the defendant within the agreement.
All right, the court recognizes that the advisory guidelines would suggest a sentence between 7 and 23 months. The courts can exercise my discretion in sentence consistent with the advisory guidelines, consistent with the plea agreement in this case. The sentence of the court that this defendant served 18 months on the minimum to a maximum of 5 years with the Michigan Department of Corrections. There's a $68 state cross assessment, $130 crime victims' rights fund fee, restitution of $1,249 to iCare One. These financial assessments will be collected through the inmate account and parole process. I've got 2 different jail credit dates here. I've got 99 on the front page. I got 67 on the second page.
He was arraigned on 9/28/23. He was arrested a few days before that.
Looks like perhaps maybe you got sentenced on a probation violation or something like that on December 1st.
Right.
That's what happened? Okay. I can't give you credit on this sentence from that day forward because your incarceration is not due to your inability to post bond. It's due to being incarcerated in another offense. So the court is only allowed to give you 67 days credit, and I'll give you that 67 days credit.
Doesn't even make sense, man.
It's like it's consecutive, but it's not
I've been
consecutive.
here for 99 days.
I'm sorry, I'm just following the lawsuit.
We
You
done?
have the right to make application for leave to appeal your conviction sentence. If you cannot afford an attorney, the court appoint an attorney to represent you on the appeal. Request for a lawyer must be filed with the court within 42 days. That's all for today.
Yeah, and I wanna bring up with that last girl as far as the cost, because Judge McConico has brought that up in the past when it has been talked about for how much it costs to house inmates. And the term static cost was used where even if one inmate is removed from the number of what it costs as a whole, basically what they're doing is taking like what it costs as a whole and then averaging it out per inmate. But a lot of those costs are costs that would not change if one inmate was removed from the pool. For instance, things like food cost. You know, taking one inmate out is not going to change how much they spent per year on food. The cost of what it costs to heat the prison, that is not going to change if one inmate is removed from that pool. So yes, does it cost $60,000 a year to house an inmate? Sure, but not all of those costs are solely on that inmate. So it's kind of, in a way, it's a little bit of a misleading number. But how else do you figure it? You have to divide it out as an average or as a whole. There's not really another way to do that. Yeah, and I have heard that jail food is not great, but like especially the meatloaf, because they focus more on making sure the inmates are getting the appropriate intake of vegetable servings and meat servings and protein and whatever the recommended dietary guidelines are. So like the meatloaf is carrots and celery and other vegetables, chopped up and ground up with the meat. And then it's not meatloaf. It's mystery meatloaf. Oh, well, see, there's the distinction. Don't get caught in a big city. Make sure if you're going to violate something, you do it in a small town. Small towns, we got that country cooking going on. Yeah. I watched too many documentaries, and then the food is prepared by inmates. So there's that, I mean, who doesn't love glass in their food if somebody's had a bad day? And this this conversation is going to bring me to my next point of the stream. So now that I'm monetized with YouTube, I get to learn about video demonetization. This one will be demonetized, as a lot of mine will be, because of what's discussed in the content. I'm not changing the type of content that I run, though. So I'm just letting you guys know that the majority of the videos that I post will be demonetized by YouTube and determined unsuitable for ad rolls. It is what it is. But y'all can still support the channel by liking, subscribing if you want to see more, sharing it, bring new people here, spread the word, spread the love. And then there's also the links in the description for outside support. So it'll be a while till YouTube even does start paying me, even the super chats and stuff, because that's YouTube. But I'm not gonna stop. I did it for completely free for 6 months. What's a couple more? But I just wanted to let you guys know that nothing's gonna change, but majority of the content that I run will be demonetized just for what's discussed in it. I have lots of yellow symbols. Slow blooming flower.
People versus Victoria Jean Marshall. Ms. Marshall is here for sentencing today. Prosecution and defense was the pre-sentence investigation report timely made available to you?
Was, Your Honor.
Yes, Your Honor.
And Ms. Frisbee, have you had the opportunity to read the report and discuss it with your client?
Yes, I have.
Do you have any additions, corrections, or challenges?
Just some updates on the attached PSI on pages 6 and 7.
Okay.
On page 6 under family, regarding her sister, Teresa Pickard, she's actually 63 years old and lives in Flint now instead of not Ludington.
Okay.
And then the next page under marriage, they should have listed her, she has, her daughter, Sade, has a her granddaughter. It has a daughter named Journey, Journi. She's 2 years old.
You should put grandkids on there, Mr. Zero? No. All right. Anything else?
No.
Is there anything that you want the court to consider before I impose sentence?
Yes, my client's currently serving a 24-month term of probation in Lake County. I think that in the grids for the, the charges on number 707, she got 90 days, 2 years probation, some fines and costs. They're still investigating the amounts. Now, if my client were to, my client lives in Idlewild, so makes more sense for her to do the probation in Lake County because she, can get there as opposed to having to do a report here. So I don't know if you want to transfer it or if it can be transferred or it can just be excluded because Lake County does have a very strict policy regarding probation violations. My client will need 30 days to pay the $798, but she can do that relatively soon. That's the total fines and costs in this case.
How do you know that?
I did know, yeah.
I haven't imposed anything yet.
I'm just saying if you do, according to under the PSI recommendations, that's how much it is. Anyway, half of the guidelines, it says midpoint guidelines here, so, well, it doesn't. It says 120-day cap, but I'm asking for time served today. My client has some medical issues, but she, this was a bad crash. She broke her neck.
Yeah, I broke my neck, my back in 5 places. I had a head injury. I broke my left knee, which the doctor want to open it back up and take the rod and plate and screws back out. But I missed that appointment December 11 because I was incarcerated. And I'm having problems with that leg. So he's gonna take it out and get me back into therapy to strengthen it back up.
Yeah, and I had to write a special note to the jail to get her certain sleeping accommodations because of her medical condition. They didn't really do what I asked, but she's been suffering she's been sleeping on the floor.
In a boat.
And no pillow, nothing like that, so.
Boat, did you say?
Yes, sir.
Like a real boat?
No, it's whatever they call a boat here. I don't know. This is my first time ever hearing of a boat. It's a plastic, long as this table. And they put the mat inside and sit on the floor.
Oh, okay. I never heard of that either.
I haven't either.
Oh,
Okay.
that was my first time. I said,
Okay.
what is that? They said a boat. I said, okay, boat.
All right.
So she's been sleeping in a boat on the floor still, and she didn't have a pillow, so that didn't help with the neck issues either. And I've written, like I said, I had to write the Boardman letter about that. Didn't even really take care of it, but anyway. So we're asking Your Honor for time served today. She's done 97 days or so, and again, Lake County's gonna take care of everything else. I have great faith in them. Plus, like I said, she lives relatively close to there. The reason she's in jail right now is her bond was revoked because she didn't realize that she was not allowed to smoke marijuana. So it wasn't like it was meth or anything like that. It was just marijuana in her system. So she's aware of that now, that's going to be a condition of her probation. So we take that into consideration, Your Honor. Again, my client has suffered greatly as a result of this incident, not just by being incarcerated, but physically. I mean, this is like the worst thing that's probably happened to her in her life.
They wouldn't expect me to live. I lost so much blood to my head. They had to give me a lot of blood transfusion.
Thank you, Your Honor.
All right. And Ms. Marshall, have you had the opportunity to read the report and discuss it with Ms. Frisbee?
Yes, sir.
Do you have any additions, corrections, or challenges to that report?
No, sir.
Anything that you want to say on your own behalf?
Well, I'm not a drinker. I haven't had a drink since my accident. So that woke me up there. And I plan to do the right thing as far as probation and everything, so I don't have to come back here. 'cause this is not where I like to be at. I think I've learned my lesson.
So what happened up in Lake County with the uttering and publishing? I mean, you're out on bond for this drunk driving case and
I know because, somebody else signed her name, but I had got a check. When they paid me, they sent me a letter, said I was gonna receive more money. So when it came, I'd never seen another name on it, just my name. So I cashed the check anyway, but, she got the money for from what the check was for. She got the money.
She paid the rest, she paid the lady back.
It was my niece. I put her on my insurance for her car, and she had an accident, but she got the money. So that was all that was.
so you signed her name to a check?
No, I didn't sign her name. Somebody else signed her name, but I did cash the check because my name was on it. It was in both our names, but I didn't know her name was on it at that time. When I got to the bank, that's when I realized her name was on it. Then somebody else signed it, and I just cashed it. But
Oh,
like
so
I
you
said,
had somebody else sign it because you didn't realize your niece's name was on it and she was
Right.
right there.
right, but she don't live in Baldwin. She live in Flint,
Oh, okay. All
but
right.
she did get the money.
Okay, I got you. All right. Mr. Stay, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
Yeah, this was a bad accident. The defendant was at 0.17 at 3 o'clock in the morning or 3 o'clock in the afternoon. I think that's a pretty strong sign of the entrenched alcohol problem here. The asking sentence address that.
All right, the court recognizes that the advisory guidelines would suggest a sentence between 0 and 6 months. The courts can exercise my discretion, sentence consistent with the advisory guidelines, consistent with the plea agreement in this case. It'd be the sentence of the court that this defendant served 75 days in the Waco County Jail. I'll give her credit for the 53 days that she served so far. There's a $130 crime victims' rights fund fee, a $68 state cost assessment, fine of $500. I'm going to place her on, well, I'm not going to place her on probation. You're already on probation for a couple of years up in Lake County, so I'm not going to put you on probation. And the court will give you 90 days from your release from jail to pay your financial assessments. You do have the right to make application for leave to appeal your conviction sentence. If you cannot afford an attorney, the court appoint an attorney to represent you on the appeal. Request for a lawyer must be filed with the court within 42 days. That's all I can say. All right, this is case number 2313310, People versus London, Antonio Graves. Mr. Graves is here for sentencing, prosecution, and defense. Was the pre-sentence investigation report timely made available to you?
Was, Your Honor.
Yes, Your Honor.
And Ms. Frisbee, have you had the opportunity to read the report and discuss it with your client?
Yes, I have, Your Honor.
Do you have any additions, corrections, or challenges?
My God.
Anything that you'd like to say on his behalf?
Yes, Your Honor. Since my client's been out on this matter, he has been working, he is a millwright. He's working at a GM plant. They're putting together a new plant in Lansing. He's been working there 10-hour shifts, 5 days a week, and soon he's gonna go to 6 days a week. So he gets up at like 3:30, he's home by 7:30 and has dinner and goes to bed. He gets up and does the same thing the next day. So he has been very productive since he's been, out on bond in this matter. And I understand that the recommendation is for a cap at the midpoint of the guidelines that was the plea agreement. And the recommendation is 90 days of credit for 3 days served. I respectfully request, Your Honor, possibly a time served sentence. Like I said, my client's been working. It's a really good job that he has, and he is a certified millwright working, doing that. He really hasn't had any opportunity to do anything else. I mean, he's staying out of trouble. He hasn't caught any new cases since he's been out. He's doing what he can. So we respectfully request time served. So, thank you.
All right, and Mr. Graves, have you had the opportunity to read the report and discuss it with your attorney?
Yes, sir.
Do you have any additions, corrections, or challenges?
No, sir.
Anything that you want the court to consider?
The same advice from my lawyer, that's about it. You know, opportunity to continue working and, you know, to show that I'm not a threat to society, a menace, and I'm a tax-paying citizen and just trying to take care of business.
So tell me what happened back in 2015 down in Ohio.
I was driving to Ohio. I had a female friend with me. I had just moved back from Georgia, and my car kind of had some of everything in it, my life. And in the trunk of the car, I also had some other people's stuff, belongings. There was a coat in there that had some pills inside of it I was unaware of, but I gave the officers the okay to search the car because I didn't feel like I was doing anything wrong. They pulled me over. They said I was going across the line, which the video came back that was not the case. There was no swerving. I had Michigan plates in Ohio, so they pulled me over. I allowed them to search the car. I definitely would not have done that if I would have known something was in the car. They found the pills. They released me, told me that because I didn't know what they were. They said if they came back as narcotics, then I'd get a indictment in the mail, which is what followed and ensued, and went from there. I ended up getting 2 years of probation for that and hadn't had any issues since up until recent.
So whose bingo card has not my pants or not my coat? Not my clothes. I don't know how we word that one. I don't know if the bingo cards ever got put up. But that's one of the boxes.
What was the maximum penalty for the offense that you pled to down there?
2 to 4 years was the guideline.
You serve any time?
I did, because I was pulled over in Big Rapids. I was living up here at the time and working for Brooks Builders, building a lake house. And so they called down there and asked if they were gonna come and get me. They said yes. So I sat in Big Rapids for I think 16 days before they came and got me, transported me to Ohio. I stayed there for another 10 days, I believe it was, before I went to court, and was released on bond after that.
How many pills were in the coat?
It's like 100.
All right. And Mr. Stay, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
No, Your Honor.
It looks like we need to put on the face sheet that he has one prior felony. That's one out of Ohio. It was scored as a felony on the prior record variable number 2, so I think that's fine. The court recognizes that the advisory guidelines, which would suggest a sentence between 0 and 9 months. The court's going to exercise my discretion, sentence consistent with the advisory guidelines, consistent with the plea agreement in this case. Be the sentence of the court that this defendant served 45 days in jail. I'll give him credit for the 3 days that he's already served. There is a $68 state cost assessment, $130 crime victims' rights fund fee, a $60 DNA fee. We place him on probation for 2 years. There's a $30 probation oversight fee for regular probation, $60 a month for electronic monitoring or tether. There's a $100 fine. There's a $100 cost. And Ms. Frisbee, do you have an estimate of how much time you have in this case?
According to the court order, forfeiture of the weapon.
Yes, I will order that the weapon be forfeited.
Like 6 hours.
6 hours?
Yeah.
All right. The courts can order that he pay $750 to the MIDC for the cost of the court-appointed attorney. How much time do you need to pay those financial assessments, sir?
What is the total of, sir?
Just a little north of $1,000.
My bond money will cover majority of that.
Did you put up cash money?
Yes, sir.
$750?
Yes, sir.
It's in your name?
Yes, sir.
Okay. We'll take a 10% bond cost. We have $675 to apply. Can you do the rest within 60 days of getting out of jail?
Honestly, I'm not sure because they won't be holding my job, so it'd be starting over again.
Give me 90 days.
Okay,
I know some other millwrights, they can find work if they want.
absolutely.
But the areas that are going to be addressed on probation are those appearing as highly probable or probable in the core compass needs scale. Mr. Graves, you do have the right to make application for you to appeal your conviction sentence. If you cannot afford an attorney, the court appointed attorney represents you on the appeal. Request for lawyer must be filed with the court within 42 days. You also have the right to petition the court for an early discharge of probation if you successfully complete half your term. Case number 2313345, People versus Tabitha Stratton.
Okay, guys. So I did everything I could to make the audio better on her, but there's something about her voice that does not pick up very well on the speaker system. She has a very high-pitched, mousy, whiny kind of voice, and it doesn't pick up well. So I did try turning the decibels up on it, and it didn't do what I had hoped it would do. But you should be able to still make stuff out, and the judge does, you know, kind of repeat the things that she says mostly.
Ms. Stratton is here for pretrial conference represented by Mr. Greer. It appears the court, this is going to be a plea. Is that correct, Mr. Greer?
It is, Your Honor.
Is that correct, Ms. Stratton? All right, would you raise your right hand, please? Do you solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Stay, would you put the agreement on the record, please?
Defendant will enter a guilty plea to an amended information charging a violation of MCL 750.411A3A, which is false report or threat of bomb, harmful device. In exchange for that plea, the people move to dismiss the original information. The people calculate the guidelines at 5 to 23 months on minimum. The people would cap at or would recommend no prison.
And Mr. Greer, has the prosecutor accurately stated the plea agreement in this case?
Yes, Your Honor.
And Ms. Stratton, is that the agreement as you understand it? All right. So the charge that you're going to be entering a guilty plea to reads as follows: that on or about August 26, 2023, that you were in the village of Hesperia, Wego County, state of Michigan, and that you made a false report of a threat of a bomb or harmful device, and that you did threaten to violate MCL 750-204, explosive sending with the intent to injure or destroy and communicate or cause the communication of threat to another person, contrary to MCL 750-411A, parents 3, parents A. This is a felony which carries up to 4 years in prison and or $2,000 fine plus cost, and the cost of the government for responding to the false report. Understand the charge and the maximum penalty. In exchange for your guilty plea to that, they're dismissing a 20-year false report of a threat of terrorism. Do you understand that? You also have a sentencing agreement that should be sentenced consistent with the advisory guidelines. The prosecutor scored those at 5 to 23 months. As long as 12 months falls within the range of guidelines, as I score them at the time of sentencing, you have an agreement that any upfront jail time would not exceed 1 year. You understand that?
Yes, you are.
So if the prosecutor scored the guidelines accurately, the least that you could expect would be 5 months, and the worst that you get would be 12 months. You understand that?
Yes.
You would also be consenting to a term of probation. You understand that? Is that your complete understanding of the agreement in this case? Have you had sufficient time to consult with Mr. Greer about your original charge, this amended charge, and this plea agreement? Well, you told me no. I mean, do you understand what's going on here today? Right? Have you talked with Mr. Greer about all this stuff? Okay, do you understand it? All right, then why'd you tell me you didn't have enough time to talk with him? Do you need more time? Okay. Subject to the plea agreement, how do you wish to plead? You understand that if I accept your guilty plea, that you're giving up your right to have a trial of any kind. You also understand that you're giving up certain constitutional rights and other rights that you would have if you went to a trial. We've listed those rights for you on a written advice of right sheet that you signed yesterday. Did you read that document? Did you understand those rights? Do you have any questions about the constitutional rights that you're giving up? Has anyone threatened you to get you to make this plea? Has anyone promised you an outcome different than what we put on the record today? Have you entered this plea of your own free will? You understand that if I accept your guilty plea, you're giving up the right to later claim that this plea was not your choice, or that it was a result of any promises, threats, or inducements that you don't tell me about today. You understand that I'm not bound by this plea agreement, but if I don't go along with it, you can withdraw your plea. You now give up your right to have a trial of any kind, all the constitutional rights and other rights that you would have at that trial, and you affirm your guilty plea. Is it true then that back at about August 26, 2023, that something happened in the village of Hesperia, Nuevo County, state of Michigan? All right. Did you call or make some sort of threat of a bomb? All right, tell me what happened.
This my anger, so I made a mistake. I never took my anger out on people. I didn't mean for it to happen. It was a mistake.
All right, but you didn't tell me what you did. What'd you do?
I pretty much went on Instagram and said I was gonna go up the school.
All right, so you went on Instagram and you said that you were gonna blow up a school.
Yeah.
What school were you gonna blow up?
I had to be a school.
All of them, or just one building, or what? High school, or what? The elementary school? All right.
I just took it out of anger. I didn't mean for it to happen. It was just a mistake.
Well, it wasn't a mistake. You intentionally put that up on Instagram. A mistake is something that you didn't mean. You meant to do this, right? All right. And what did you think was going to happen when you threatened to blow up an elementary school? Well, you had to intend some sort of outcome. I can't hear you.
I knew I was going to get into trouble.
All right, but you know that would cause a certain reaction with the people in the school and the police, right? What were you so mad about that would, in your mind, justify doing this?
Here it is.
I was playing video game with my fiance and his friends, and they made me mad, and I just backed out.
I was playing a video game with my fiance and his friends, and they made me mad. So I just backed out and did that. You want to know what makes me the most mad out of that whole concoction of words? She has a fiance? And I'm sitting here with 2 cats and a dog. And she's got a fiance. Life ain't fair, y'all.
How old are you?
22.
You get mad because you're playing video games, and the response to that is to threaten to blow up the school. Are the attorneys aware of any promises, threats, or inducements which have not been put on the record?
No, Your Honor.
No, Your Honor.
Is the defendant competent to enter this plea?
She is, Your Honor.
She is, Your Honor. She's been determined competent by the forensic department, Your Honor.
All right.
that means that they had questions enough to request a competency hearing. And she passed.
And is the court provided MCR 6.302?
Do we have?
Yes, Your Honor.
All right, court does accept the plea. Do you find it to be knowing, understanding, voluntary, and accurate? I'm going to refer her to the probation department for the preparation of the pre-sentence investigation report. We'll set sentencing in this case for February 5th at 2 o'clock. That's all for today.
Your Honor, would the court consider a PR bond? She's been here since the date of her arrest, which is about 4 months.
Okay, she's looking at least 5 months and up to a year. Mr. Stay, any thoughts on that?
Your Honor, I would oppose it. Mr. Greer did talk to me about this. The defendant was on bond for making another threat in Shannon County. She obviously presents as sort of a meek individual, but this threat is very particular. This court I know has reviewed these cases before and seen them. Sometimes I'm going to blow something up. So sentences long with a picture of the library, and that I'm right outside the library with some bombs planted near the building. You'll never find them. That mean it's a couple sentences long. She was already on bond. I wouldn't be the least bit surprised if this defendant got out and did this again. She can't control herself. And this court knows how much on edge that puts the community.
Yep.
Mr. Greer, is that accurate?
Your Honor,
let me finish asking the question.
I'm sorry.
Is it accurate that she was out on bond for another false bomb threat when she committed this offense?
In Oceana County, it is true.
Okay, all right, well, yeah, you're not going anywhere. Request for bond is denied.
Thank you, Your Honor. All right, I'll be down to see you. We're gonna have to sit.
I hope you
Versus
enjoy
John
gardening, LSD.
Stepien, case number 21-12879 FH. He was previously found guilty at a probation violation hearing. Today is set for sentencing. Prosecution and defense was the pre-sentence investigation report timely made available to you.
It was, Your Honor.
Yes, Your Honor.
And Ms. Frisbee, have you had the opportunity to read the report and discuss it with your clients?
Yes, I have.
Do you have any additions, corrections, or challenges?
Just the credit, because this was originally scheduled for November 7th, so it just need credit till today.
350 is what we calculated it as.
Yeah, I have 349. Okay. Yep. So that's all.
All right. Anything that you want the court to consider?
Well, you heard the testimony from my client. The only thing I would request would be that he doesn't want to go to prison, obviously. I mean, he wants to go to prison, but the other thing I would propose is maybe he could do, he's got a little bit of time left. He could do the balance of the year, and any of the good time that he's accumulated, he could serve. That's, that would avoid prison. So, and then his probation doesn't necessarily need to be revoked, but in that situation, but we would respectfully request that the court consider that. Thank you.
All right, and Mr. Stepien, have you had the opportunity to read the report and discuss it with Ms. Frisbee?
Yes, Your Honor.
Other than the jail credit, do you have any additions, corrections, or challenges to the report?
No, thank you, Your Honor.
Anything that you want to say on your own behalf?
Yeah, I, do believe this lesson here was for me to believe. I believe wholeheartedly. Picking your friends and choosing them wisely is the biggest lesson I've learned here, and that's all I want to say.
All right. Mr. Stay, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
I would ask the court to sentence the defendant to the recommended 23 months. This is an assaultive event. The defendant is not taking responsibility for it while on felony probation.
All right, the court recognizes that the advisory guidelines would suggest a sentence between 10 and 23 months. The courts can exercise my discretion and sentence consistent with the advisory guidelines, consistent with the plea agreement in this case. be the sentence of the court that this defendant served 18 months on the minimum to a maximum of 5 years with the Michigan Department of Corrections. I'll give him credit for the 250 days that he served so far. He still owes $77.50 towards the financial assessments. The court would order that those would be collected through the inmate account and the referral process. He would be discharged from probation as being unsuccessful. Mr. Stepkins, you do have the right to appeal this conviction sentence if you wish to be represented by an attorney but could not afford one. The court would appoint one to represent you with public expense. The request from the lawyer must be filed with the court within 42 days. That's all for today.
You want to credit 250 or
350.
350? Please.
I may have 350 is the credit he gets.
Thank you.
This is case number 2313294 FH. Mr. Townsend is here for sentencing. Prosecution and defense was the pre-sentence investigation report timely made available to you.
It was, Your Honor.
Yes, Your Honor.
And Ms. Frisbee, have you had the opportunity to read the report and discuss it with your client?
Yes, I have.
Do you have any additions, corrections, or challenges?
No, guidelines are fine, everything. I don't have any additions, deletions, or corrections.
Anything that you want the court to consider?
Yes, I'd like the court to be aware that my client has been employed for 2.5 years working at the same job. He does have the support of his family, and he actually resides with his mother right now. So she lives with him. He's been attending AA and to address this drunk driving issue, and he has not had a drink since the time of the arrest. Talked to him about that some length. So, we're respectfully requesting. I realize that the cap is at 6 months, but he's going to lose his job if he goes for any long period of time. And like I said, he's been working there for 2.5 years, which is pretty good for most of my clients. So I understand that this was a good offer, not charging the habitual offender notice and dismissing one of the counts, but respectfully, Your Honor, we would ask for maybe just some minimal jail time, or maybe he could at least do weekends so he can still maintain his employment. Thank you.
All right, and Mr. Townsend, have you had the opportunity to read the report and discuss it with Ms. Frisbee?
Yes, Your Honor.
Do you have any additions, corrections, or challenges?
No.
Anything that you want the court to consider?
I'm trying, I came here with the understanding that I'm doing 5 to 6 months. I already accepted that in my head. I'm hoping for the best, Your Honor.
All right, and Mr. Stay, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
No, I believe the court's fully advised in this case.
The court recognizes that the advisory guidelines would suggest a sentence between 0 and 9 months. The courts can exercise my discretion and sentence consistent with the advisory guidelines, consistent with the plea agreement in this case. Be the sentence of the court that this defendant served 120 days in the Whitehall County Jail. Give him credit for the 3 days that he's already served. There's a $68 state cost assessment, $130 crime victims' rights fund fee, fine of $500, court cost of $100. The court is going to place him on probation for 2 years. There's a $30 per month probation oversight fee for regular probation, $60 a month for electronic monitoring or tether. And Mr. Townsend, did you post a cash bond?
It was through a bond aid.
Bondsman, okay, all right. How soon can you pay your financial assessments?
Couple of weeks after I get out of.
Right, the court will give you 60 days after release from jail to pay your financial assessments. You do have the right to make applications for to appeal your conviction sentence. If you cannot afford an attorney, the court appointed attorneys represent you on the appeal. The request for lawyer must file with the court within 42 days. You also have the right to petition the court for an early discharge of probation if you successfully complete half your term. Okay?
Yes, Yes, Your Honor.
for today? All right. This is case number 2112870 FH People versus Daniel Anthony Schmidt. He's represented by Mr. Greer. We're set for a probation violation hearing today. There's been a recommendation made by the probation department that if he enters a plea to a non-technical violation, that they would revoke his Homes Youthful Trainee status. They're recommending that he serve up to 22 months in prison to a maximum of 10 years, and his probation under Heidi would be revoked. And Mr. Stay, do you adopt that recommendation as an offer in this case?
People would.
So, Mr. Greer, does your client wish to take advantage of that offer? Does he wish to have a contested hearing, or does he want this case postponed to see what happens in Muskegon County?
Your Honor, what my client is willing to plead to are technical violations. And so in order for the prosecutor to get the desired result, it would include him admitting what he's charged with in Muskegon. So we do need to adjourn this, but you know, he was here about 3 months ago. I thought somebody would have notified the, we were here in November 7th. And apparently either Muskegon County was never notified or they just didn't act on it. So, you know, I was of the impression that the prosecutor or probation agents would notify, but maybe it's my duty. I don't know. You know, I mean, he's sitting here on this open warrant. He hasn't even been arraigned in Muskegon County.
Oh, okay.
So, I mean, if the court would adjourn it, I will get a hold of Muskegon. But, you know, I mean, but I think that, you know, probably for a little more teeth in it, maybe the prosecutor notify.
All right, so you want the case adjourned then?
Yes, Your Honor, please. And I'll notify Muskegon County that he's here.
I'm having my staff send an email.
Oh, thank you.
Or calling them right now.
Thank you.
All right, is that what you want to do, Mr. Schmidt?
Yes.
Okay. All right, we'll reset this case for a probation violation hearing, February 5th at 2:10.
Thank you, Your Honor. Listen. Okay, in Muskegon, and then we'll take care of this. All right. All right.
This is case number 2213109 FH People versus Rick Clifford Allen Fosberg. He is here for sentencing. Prosecution and defense was the pre-sentence investigation report timely made available to you.
It was, Your Honor.
It was provided in a timely manner to our office, Your Honor, and I brought it up and reviewed it at the jail with Mr. Fosberg and left a copy with him. And so, yes, it was provided in a timely manner, and we've had an opportunity to review it. And I think there may be one issue, but I know the local probation office doesn't make any determination on SAI eligibility. It's done at quarantine. But I believe that now that the second offender, habitual offender has been brought, that he will be determined to be eligible, at least screened through corrections for eligibility purposes, in that the entry in the report is kind of a default entry so that the local probation office doesn't make a determination on that issue. That's the only, but there are some other information when the time comes for extenuation mitigation.
All right, so you believe the report was accurate?
I believe it is, Your Honor. Basically, as far as the content, with the exception of that issue, which obviously is determined once he gets to quarantine, if the court sentences him to prison.
Okay. Is there anything that you'd like to say on his behalf?
There certainly is, Your Honor. Your Honor, in our sentencing memorandum, and the reason I furnished those to the probation office, the letters from his children, just having gotten to know this gentleman more than a year ago, and his mom and dad, and his sister Jennifer, he comes from a very stable two-parent family background. And he also had a long-term marriage, 27 years, and his kids are very stable from any communication I've had with the family. So why is he here in court looking at a 3 to 20 or whatever the court determines to be the sentence? And when we go through his history, it is all substance abuse, Your Honor. Initially alcohol, marijuana, now methamphetamine. And at some point, you know, having been at this for a while, a person does have enough bad things happen and see the consequences of what they're doing on their family, whether it's their own children, and in his case, his mom and dad, and on his long-term marriage where he's been divorced since 2018, but there's some hope they can reconcile if he can abstain. But Your Honor, last Thursday, his dad had a stroke and he's actually in intensive care right now in Grand Rapids. And his dad, that's the only reason his dad's not with us today. He's been up here with his mom. Mom is with us as well as her sister in the courtroom. But his father's in intensive care and it really presents a problem situation. He'll address it further, Your Honor, but it's kind of like have enough bad things happen. And are there enough present needs now that the prognosis is different than what it might have been? And I believe there are. He does have a very stable work history, Your Honor, even though he's had these substance abuse issues. He's a licensed builder. He's like a jack of all trades as far as building, construction, repair, that there are many, 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 many redeeming factors here, whether it's stable family of origin, whether it's close relationship with his children and two grandchildren, stable work history. Basically, Your Honor, if there's any way the court could give him the opportunity to prove himself, whether it's on a, obviously he's done 192 days in jail, as indicated in the report. If the court were to give him probation with a year in jail, he'd have, with the good time, because my understanding is he has been completely compliant on the jail front, including working with the jail therapist and the substance abuse therapist. That was the information that was given to me through.
So what you're saying is he's been able to do everything except be sober. Got it.
To the community mental health. But Your Honor, if you can hear him out today, he's going to be begging you to let him be here in West Michigan to help his mother. And hopefully his dad will survive his present condition. But we'd ask the court to allow him to not get the 36 months that is capped, the 3 to 20 that is capped in the plea agreement with the credit, but to even do better than that and to allow him to stay in West Michigan and to be here to help his mother and dad, given this imminent situation that they now have. And the sister, Your Honor, I've talked to her many, many, many times, very well employed. She lives in California. She's a very productive, law-abiding person, but she's not here. So there really isn't anyone here to help his mom with his dad's condition.
Okay, anything else, sir?
I believe he would like to reiterate those points, and I know the court will allow him to do that, Your Honor.
All right, thank you, sir.
Thank you.
And Mr. Fosberg, have you had the opportunity to read the report and discuss it?
Yes,
sir. With your attorney?
Yes, sir.
Do you have any additions, corrections, or challenges?
No, just basically what he said is that, I mean, if you look at my whole records, all I've done is drugs and alcohol. I don't steal, I'm not a liar, I don't cheat. And I even told Mr. Zero back here, I said, I'm not a drug dealer. I said those drugs were in my possession. That's why when I think you remember when I was in the courtroom, you asked me if I sold it. I said no. And then you asked me if I gave it away, and I said I guess so. You kind of got a little chuck out of it. But sir, I mean, the only problem in my whole life is it's just been over drugs and alcohol. I lost my wife because of that, which I've been talking to her lately, and she said that she'd be willing to take me back if I quit doing drugs. In which I told her that I'm definitely in, because this.
You know, I hate to say it, but if you give drugs away, you're still a drug dealer. You are. If you're doing anything that is putting drugs in the hands of someone else, you're a drug dealer.
This is costing me everything I got right here. But now my dad being, he went into for a second stroke, and he's in intensive care right now. And it's like my mom needs me, and I don't have if I'm in jail here, in prison or something, and I lose my dad and I don't get to see him or about coming to help my mom, I ain't never gonna be able to forgive myself, you know? I got 2 little grandkids. They keep asking their mom, which is my daughter, where's your grandpa? Where's your grandpa? Because we do stuff all the time. And it's like, if you look up my kid's record, they don't have any record. They ain't got nothing but a speeding ticket on the record. So I raised 2 good kids. And I've been licensed builder and had my own company for over 20 years now. That's since 2002. And other than drugs and alcohol, that's the only couple I've got in my whole life. I mean, I'm willing to do whatever you need me. I will take drug tests for you every single day for the next 10 years. I'll go to a rehab. I'll go put me on a house arrest, put me on probation, whatever you can do in terms of going to prison and losing my family. I mean, I swear to God, I am done with these drugs. I'm not doing them anymore. The only way I can get my wife back is if I quit. And the only way I can stay drugged and just stay out of trouble, I don't want to get in any more trouble. And I swear to God, I'm done doing them. I swear to God. I will, like I said, do anything. Put a tether on my ankle or I'll go drug test every single day. Every single day, whatever it takes. I'll go to a rehab facility, whatever, go back and forth, whatever. If you could just find in your heart, just let me get out of here so I can go and help my mom. My parents have been there to help me my whole life, and I need to be there for them.
So if you had a great childhood, your parents were there for them, and you were working and carrying, doing all the things that you're supposed to do. How did you end up with 1 prior felony, 7 prior misdemeanors, and a drug habit?
All from drugs and alcohol. I had 2 DUIs and I had open container. They're all related to drugs and alcohol.
Okay, but why? Why do you use drugs and alcohol?
Can't really answer that. I mean, that's just something I don't know. That's why I'm asking myself the same question right now. And all I can say is I tried something just thinking it was when people were out having fun or something, and that it. I don't have a victim. I thought the only person I would be hurting was myself, and not anybody else.
88 grams on it. Who knows what you went up to the Door County with? But what they caught you with was 88 grams.
I understand that, but and I told Mr. Zrup that the girl that I was with, she had a previous drug charge. I went to court with her in Walker, Michigan, Renee Terhar. She was facing 40 years, and she put that into my car, that 88 grams. Mr. Zrup even said, why would you plead guilty to it? I said, because Mr. Dodge here told me that anything in my vehicle is my responsibility. So I'm here saying I'm accepting responsibility for them drugs that are there. And I do use drugs. What was on my boat was mine. They found like a 1/4 gram or 1/2 gram on my boat. That was mine. But it doesn't even matter because the drugs are the drugs. I'm telling you, I'm done doing them. So I won't be with another girl like that that's got that or anything. I want to get back with my wife, the person that I've been with my whole life, other than the last couple of years. She does no drugs. She has no record. And that was the reason why we got split up, because of me using drugs. And that's like I said, so I've lost already something that really means dear to me by losing my wife. I've been talking to her since I got in here, and she told me that she's going to give me another chance if I can prove to her that I ain't never doing drugs again. And I told her there's no way I'm doing drugs again. I'm gonna get me back. And since then, just Thursday, my dad had a stroke and I was in intensive care. And it's like, as of right now, he's paralyzed on one part of his body and he can't hardly talk. He's 85 years old. Okay, it's the second stroke. He's already had a heart attack, triple bypass. Then he had a stroke. He's had like 4 stents put in. Now this is his second stroke. And he's 85 years old. I don't really need to say more than that. I need to get out there to see my dad and help my mom. My mom and dad have been there for me throughout my whole life. This right here has been the biggest eye opener for me in my whole life. And I've never been in jail this long, even right here. This is as long as I've ever been in jail. And I'm telling you, I am done doing this, Your Honor. I'm totally honest with you. I ain't touching this shit ever again. Never.
Mr. Walburn, anything that you want to say?
I don't have anything, Your Honor.
In this case, the advisory guidelines would suggest a sentence between 24 and 40 months. Courts can exercise my discretion, sentence consistent with the advisory guidelines, consistent with the plea agreement in this case. Do the sentence of the court for this defense for 24 months on the minimum to a maximum of 20 years with the Michigan Department of Corrections. Give him credit for the 192 days that he's already served. There's a $68 state cost assessment, to $130 crime victims' rights fund fee. The court direct those collected from the inmate account and parole process. And Mr. Fosford, you do have the right to make application for leave to appeal your conviction sentence. If you could not afford an attorney, the court appointed attorney represents you on the appeal. The request for lawyer was filed with court within 42 days. That's all I'm saying.
Yeah, I hope he's serious. I hope he gets his act together. I'm a little skeptical.
This is case number 22-13030, People versus Jeffrey Andrew Atwood. He's represented by Ms. Frisbee. Mr. Atwood, did you receive the amended warrant for probation violation?
I did.
Did you read it?
I did.
Did you understand it?
I do.
All right. Did you also receive your probation violation arraignment advice of rights form?
I did.
Did you read it?
Yes, sir.
Did you understand it?
Yeah, I've got some objections I'd like to make.
Well, hang on. Getting kind of the cart before the horse, right?
Uh-oh.
And you signed that probation advice of rights form today, is that correct?
Yes, sir.
All right. All right, so we have 18 counts of violation here. So the allegation is that you were placed on probation to this court for maintaining a drug house. I think that was habitual offender third.
That's in the paper indicates, Your Honor.
Yeah, all right. So that is a felony which carries up to 4 years in prison. Do you understand that? All right. The allegations here are that you violated condition number 3, which requires you to report to your probation officer. That the allegation is that on July 3rd and July 11th, you failed to report as instructed. You understand the allegations contained in count 1?
Yes.
All right, so we've got counts 2, 3, 4, 5, 6, 7, 8, all alleged violation of condition number 2.4, that you're not to use or possess controlled substances. Be with anybody that has those without a doctor's prescription. And these alleged in count 1, that June 2nd, you tested positive for admitting using amphetamine. You understand the allegations contained in count 2?
Yeah, it's like,
Man, I'm asking if you just understand the allegations.
okay, yeah.
That's what they're accusing you of.
Right. Well, part of my question and objection, Judge, is because like right now you're just reading the count 1 or count 2, but then it's also duplicated again in count 3 and count 4, and then again in like 10 and 11. It's all one and the same. You can't have one without the other.
I can explain that to you. So the same conduct can violate one or more provisions of your probation. So Using drugs is violation of condition number 2.4, but it's also against the law. So then it can be a violation of condition number 1.
Part of what I was referring to is like the one that alleges methamphetamine, the other one is amphetamine. I mean, it's one product. You can't use one without the other.
That's wrong. They're two different substances.
Right, but I just think that the redundancy is just sole purpose is to make it out to be the worst person to justify the punishment.
Sir, we're not here for sentencing. We're not here for a hearing. I'm just asking you if you understand the allegations that they're making against you.
And thank you for your interpretation of science, but we're going to go with reality.
You understand that?
Yeah.
All right, so count 4, June 16th, that's for counts 4, 5, and 6. June 16th, that you tested positive for amphetamine, tested positive for methamphetamine, and tested positive for cocaine. Do you understand the allegations in those counts? Counts 7 and 8, again, are a violation of condition number 2.4 that you not use or possess controlled substances. This is alleged on July 10th for use of amphetamine and use of methamphetamine. Do you understand the allegations contained in counts 7 and 8? Count 9 is violation of condition number 2.8. When on or about July 10th, you failed to attend or complete substance abuse counseling as instructed by your field agent. Do you understand the allegations contained in count 9?
I do.
Count 10, violation of condition number 2.4, that you're to report police contact within 24 hours to your field agent. The allegation there is June 29th, you had contact with the Nuevo County Sheriff's Department and failed to report this police contact to your field agent within 24 hours. Do you understand the allegations contained in count 10?
Yes.
Count 11, 12, 13, 14, 15, 16, 17, and 18. Those are all non-technical probation violations. They all involve violation of condition number 1, that you not violate any criminal law of any unit of government. 11 says that on or about June 29th, you violated Michigan state law when you damaged someone else's property. You understand that allegation?
I don't, because I was never charged with any crime there.
Okay, but I'm just asking you if you understand what they're accusing you. You can violate the criminal law without being charged.
I mean, without any documentation, I can't confirm or deny.
Right, but that's what they're charged, that's what they're accusing you of. I'm not saying whether you did it or didn't. This is just, the prosecutor's gonna have to prove this by a preponderance of the evidence when the time comes. This is just informing you of what they think they can show.
Right.
I don't know how many times I can explain that to you. Understand that?
Try a couple more, Judge. Try a
Number
couple more.
12 is on about June 2nd, that you used amphetamine. Do you understand the allegations contained in count 12?
I understand the nature of it, yes.
Count 13, June 2nd, you used amphetamine. Do you understand the allegations contained in count 13?
I understand it seems like a duplicate charge, so.
Count 14, July 10th, that you violated the Michigan state law when you used amphetamine. Do you understand the allegations contained in count 14? Count 15, again, July 10th, that you violated Michigan state law when you used amphetamine. Do you understand the allegations contained in count 15?
But it seems like the same count as 14, yes.
Do you understand what they're accusing you of?
Doing two different things of one act, yeah.
Count 16, this is alleged to have occurred on November 29th. That's 16, 17, 18, that you violated Michigan state law when you ORV trespassed. You understand the allegations contained in count 16?
I was never charged with trespassing, so I do not understand that.
Count 17, that you violated Michigan law, state law when you fled and eluded the police. Do you understand the allegations contained in count 17?
I have not been formally charged yet, I don't believe.
Just give up, Judge. Just give up.
And count 18, that you violated Michigan state law when you resisted and obstructed a police officer. Do you understand the allegations contained in count 18?
I have not been advised that I've been charged with any of those crimes.
Sir, I already told you once that you don't have to be charged with a crime to have violated your probation by violating Michigan state law. So that may be coming, it may not, I don't know.
I'm not,
But
well, I'm
this
just
is
saying,
just what they're accusing you of. They're not, these are accusing you of violating a condition of your probation.
I
The
understand
allegations
the
of new criminal
accusation.
conduct will come later if they're gonna come at all.
I understand the accusation.
There you go,
I
perfect.
have
Ms.
been charged.
Frisbee, how would you like to plead?
Not guilty.
All right, we'll enter a not guilty plea for Mr. Atwood. And now we need to discuss bond. Ms. Frisbee, anything that you want the court to consider in setting a bond?
Mr. Harewood lives in the Grant. He's not currently employed. He's not sure if any of these things have been charged and they're in Muskegon. They're not really, so I can't really verify that. He has a whole family lives in this county, has strong ties, parents, grandparents, sisters, entire family. He may have many years ago, failed to appear before.
All right. And Agent Thompson, anything that you want the court to consider?
Your Honor, I'm covering this for Agent Musser, or Musselman rather. He asked for the bond to remain at $30,000 cash assured, and I concur with that.
All right. Mr. Holmes, anything that you want the court to consider?
Given the number of allegations and the underlying severity of the crime that he's on probation for, I think $30,000 is very modest. And I'd ask you to keep it at that, if not increase. Thank you.
All right, we'll set the bond for $50,000 cash or surety. I will set this case, Mr. Atwood, did you plan on hiring an attorney to represent you in this case?
No.
Do you wish to be represented by an attorney?
I do.
Okay.
If I get a competent attorney.
That? I'm sorry, I didn't hear what you said.
A competent attorney, then yes.
It'd be
Okay.
more competent than you.
Have you been working, sir?
No.
All right. Do you have any money or assets?
No, no.
All right. The MIDC will appoint John Greer to represent you in this case. We'll set this case for a probation violation hearing December 12th at 10:10. That's all for today.
Yeah, his bond went from 30,000 to 50,000.
72 FH. Mr. Cruz is here for sentencing, prosecution and defense. Was the pre-sentence investigation report timely made available to you?
Was, Your Honor.
Yes, Judge, it was. And Mr. Prysock, if you had the opportunity to read the report and discuss it with your client? I did, Your Honor. Do you have any additions, corrections, or challenges? No. Anything that you want the court to consider?
Well, Judge, I submitted some letters to the court, one on behalf of this employer, an owner of Never Enough Auto Custom Shop in Grant, Michigan. He's been working there, been a customer for 14 years, then he was hired to work at the store, at the shop. I think the letter is indicative of his character, Judge.
I don't have that letter.
He did that last week, Judge. But
Okay, thank you.
also, Judge, we emailed letters from his family as well as a statement from Julio. And the letter from Julio is his statement, Judge. And I'll get to that after we go through the PSI. But there's 14 misdemeanors on the PSI. If you look at his record, all of them but one, which occurred in 2008 in the Muskegon County ag assault, are all driving while license suspended violations. That's because he's always worked. Had difficulty with getting his driver's license back when they had those driver responsibility fees. He now does have his driver's license. So he's been legal for some time, Judge. All of those traffic violations were due to him working to support his family. So we're asking the court to take into consideration his job, his employment, the letters that we provided for his character. This was an unfortunate incident. He was concerned for his daughter and some of the people that she was involved in. He truly thought that if she went somewhere with this person that came to the house, her life would be in danger. That doesn't excuse his actions, but we're hoping that that's an explanation that the court could understand. As for Julio, he says, Your Honor, my actions were uncalled for that night. I spent a couple of nights in jail asking myself how I could lose my self-control. From the moment I stepped foot in that jail cell, I knew that I would accept my punishment, not try to fight this. I am thankful that my attorney was able to secure a plea deal with the prosecutor. I know the sentencing recommendation from the prosecutor is that my guidelines are 0 to 6 months. Whatever sentence you give me, I accept, but I hope you find it in your heart to give me a second chance. I work full-time, come from a good, hardworking family. They're here in the courtroom today, Judge. I support and provide for my children. I don't drink or do drugs. I'm almost 40 years old and try my best to stay out of trouble. I ask that you please sentence me to any term of probation with what other terms you can see fit. I guarantee that I will successfully complete probation, pay all my court fines and costs. A jail sentence would cost me my job, my ability to pay my bills, my child support, and support my family. I'm a man of my word. I don't make excuses for my actions, but I accept whatever sentence you choose to give me.
Did anybody count how many times he said accept in that letter? And if I remember correctly, the reason I put this in was because he doesn't accept it as well as he says he accepts it. Man, he accepts it. I wish you guys could hear, but you know, the CEO of the paw firm is up in the corner up there, and she's snoring logs during these clips. It's hilarious. And when I said in the chat earlier, well, I guess Ava gets a Pop-Tart, it's because as I was, heading back to the computer, I dropped my plate and the Pop-Tart went kaboom on the floor. And I called for her, very loudly called for her, and gave up the Pop-Tart still on the floor in the kitchen. It's waiting for her. Come in here. She's passed out cold. And there she remains. And she's snoring.
All right, and Mr. Cruz, have you had the opportunity to read the report and discuss it with your lawyer?
Yes, I have, Your Honor.
Do you have any additions, corrections, or challenges?
I don't, Your Honor.
All right. Anything that you want to say on your behalf that you didn't put in what your attorney read or the letter that I received today?
Just once again, that I just honestly have a lot to lose here. If I do end up going to jail, I'm losing all what I work for. And kind of got myself quite a bit ahead these last couple of years. And finally, I was looking forward to enjoying my 40 years on where I got myself in life. And I ran into this incident here. And I'm learning from it, believe me. And I just really wish you could just consider that I'm not a criminal. I made a mistake and I'm here to face that. And, I know that depending on what happens today would really affect my life. And having to start all over again, being a 2-time felon, it's going to be quite hard too. If I end up having to lose my job, it's pretty much, I am sorry for what I did, and my intentions were just to make sure that my daughter was okay. And I thought I did the right thing by calling the cops, because I did call the cops. Looking back at it, I kind of asked myself, why did I? But at the same time, all I was trying to do was the right thing to figure out who these individuals are. That has been an ongoing investigation prior to that night. It was about a 3 to 4 day investigation. Multiple police reports have been made. There was a lot of cops that came to the house, so they were all aware of what was going on. And that night, I just took it upon myself just to try to figure out who these people were. And by calling the cops and giving the license plate number, I Well, I took it a little to the extent by grabbing my gun, but that was just because I didn't know who I was dealing with. These individuals were coming from Grand Rapids, and I know it's a little bit of a different nature out there than what it is over here. So just for my personal protection, I made a mistake by grabbing my gun.
So I get the fear of being a parent, and when you have a child who's doing stupid things with people that may not be the best for her, the reaction you don't do is grabbing a firearm and chasing after a vehicle that just happened to pull into your driveway that you don't know if is the people that you think your daughter's associating with or not, and then chase this stranger through town waving the firearm at them and screaming. That's what you don't do, because that's how your daughter ends up without a dad, either through incarceration, or what if these people are as bad as you think they are? Don't you think they've got weapons too? You really want to put yourself in a position where you're taking yourself out of your daughter's life forever? Come on, man.
Wasn't no intention to hurt anybody, to kill anybody. It was just an instinct. Here I am now, facing these 2 felony charges when the individual, I didn't even know who he was. I didn't know what was going on with that side of crew that my daughter was hanging out with.
All the more reason
Obviously,
you shouldn't have done it.
That person isn't here. That individual hasn't even showed any reports or anything like that. I just think his intentions weren't the right intentions that night, and I think that's why he hasn't showed face or anything like that. They did have something planned that night. And on behalf of my daughter's safety, once again, there was reports that were made prior to that incident, a couple days of reports actually. The cops were over to my house. So once again, I just hope that you could consider that I do have a full-time job and really, really hard last couple months, that's for sure.
Couple questions for you. What's your definition of a criminal?
Somebody that doesn't abide the law, somebody that doesn't consider anybody else's well-being, except for themselves.
So you've got 14 prior misdemeanor convictions, but still you don't think that you're a criminal?
I guess if you look at it as abided by the law, I guess if you would put it that way, then yes, I would say for driving without a license.
All right, and an aggravated assault.
Yes. Yep.
I understand from the report that you were trying to elicit the police help in helping your daughter leading up to this night, but I didn't get from the report that you called the police when you saw the vehicle on the security cameras, right?
We did call the cops, sir.
When?
My uncle made that call, and I wasn't able to make the call because I had dropped my cell phone. And once I had that chance to make a call, that's when I made the call.
You made the call to the police before you ever went over there?
I made the call to the police after I was able to get a plate number, but no, I did not call the cops prior.
After you showed him your gun and after you chased him down M37?
Right.
The report says that you fired shots at him.
I did not. I did not. I know I did not fire shots at him.
The excuse that you gave the police was that you thought that your vehicle was backfiring. I can't remember the last time I heard a vehicle backfire. I mean, that sounds like nonsense to me.
Actually, after he had went in the ditch, the vehicle wasn't running correctly. It did take some damage. And like I said, I didn't shoot any rounds at the individual. My whole intentions were to try to get that plate number to turn that over to the cops.
No one
Why'd
believes.
you hide the gun and then why'd you hide the magazine then?
The gun didn't have a magazine and I kind of had my gun sitting outside because I really honestly don't like guns. I don't care for guns at all.
No one believes you.
Did you ever consider that whatever vehicle pulled into this driveway may not have had anything to do with whatever was happening in Grand Rapids?
Honestly, I did it because of the fact of all that was going on prior. I didn't consider, and then for the time frame at night, you know, almost 1 o'clock in the morning, it was just really suspicious. And the style vehicle as well. Just had a lot going on in that time frame in my mind for my daughter's well-being. And there was previous reports on all this night too.
What if you pulled into somebody's yard and then somebody comes screeching up behind you? You're there minding your own business, and 1 o'clock in the morning, they come up behind you, they show you a gun, scare the crap out of them, chase you down the road, fire gunshots at you, you end up running off the road in your vehicle. You'd want me to do something to that guy, wouldn't you?
Well, Your Honor, honestly, I wouldn't have ran. If I was somebody that had no wrong intentions or any wrongdoing, I wouldn't have no purpose to run. I would stop and face that person that is coming up to me. That's why.
They're coming up to you with a gun.
Even at that, Your Honor, if I wasn't doing anything wrong, I would have stopped and made myself known what I was doing at that point in time. at
No.
night. That's
No.
why I was really concerned because of the way this person sped off. They went through the yard and like ran over trees, like dug up the yard, went through 2 yards to get away in the manner that they ran. To me, like I said, I thought my daughter was in this car. If I was able to see the individual in the vehicle because it was fully tinted, if I was able to see that one person was in that vehicle and that my daughter wasn't in that vehicle, I would never have ever gone after that car. I would have done the right thing by calling the cops right there and then. But I thought my daughter was in that car.
All right, Mr. Stay, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
I think the court recalls this plea was kind of difficult to take. I don't think we've gotten a full accounting from the defendant. It's difficult for me to give you the perspective of the other side. We haven't had any contact with the victim in this case. Even though we have contacted it, at least by letter in that regard. The defendant does have an aggravated assault, so this is not a situation where we have somebody with no criminal record. People also did not charge felon firearm in this case. So I do think there's probably some jail time, further jail time that's warranted in this case.
All right, we're dealing with 2 counts. Count 1, assault with a dangerous weapon. The court recognizes that the advisory guidelines would suggest a sentence between 0 and 17 months. The court's can exercise my discretion, sentence consistent with the advisory guidelines, consistent with the plea agreement in this case. Be the sentence of the court that this defendant serves 90 days in the Whitehall County Jail. Give him credit for the 3 days that he's already served. Count 2, carrying concealed weapon. The court recognizes that the advisory guidelines would suggest a sentence between 0 and 9 months. The courts can exercise my discretion, sentence consistent with the advisory guidelines, consistent with the plea agreement in this case. Be the sentence of the court that this defendant served 90 days in Whitehall County Jail. Give him credit for the 3 days that he's already served. Count 1 and count 2 would run concurrent with each other. There is a $130 Crime Victims' Rights Fund fee, $68 state cost assessment for each count. Court is going to place the defendant on probation for 2 years. There's a $30 per month probation oversight fee for regular probation, $60 a month for electronic monitoring or tether. The areas that are going to be addressed are those listed as highly probable or probable in the Core Compass needs scale. The court does believe that additional jail time is appropriate in this case for a number of reasons. Number 1, he went into the situation with a gun. Didn't actually know who was there, if the person there had ill intentions. Chased the vehicle down the road, causing that person to crash. That person indicates that shots were fired at the vehicle. Very, very dangerous situation. all the way around. Now, you may be right about this guy. Don't know. The situation seems to be like maybe you were, because usually if someone gets a gun pulled on them or shots fired, at them, usually they want to be in cooperation with the prosecution. But I don't know. That's a maybe. But what I do know is, number one, that you did not own your actions at the time we took the plea. Talking to you today, and you're still kind of wavering and blaming, and I think still you don't think that you did anything wrong. I think you're sad that you got caught. I think you're mad that you're going to go to jail, but I think you're still thinking that you did the right thing under the circumstances, and you did. So the court would direct that your financial assessments would be paid within 60 days of your release from jail. And you do have the right to make application for me to appeal your conviction sentence. If you cannot afford an attorney, the court will appoint an attorney to represent you on the appeal. Request for a lawyer must be filed with the court within 42 days. You also have the right to petition the court for an early discharge of probation if you successfully complete half your term.
Yes.
Okay. This is case number 2012474 FH, People versus Dallas, John Roney. Mr. Roney, you are here for an arraignment on a probation violation warrant. Looks like we got a 20-count probation violation warrant. Did you receive a copy of that document, sir?
I received a copy with like 6 violations from back in August. I would say I don't know. I haven't been found guilty of anything. I've got charged with something I have no idea.
Okay. Did you receive a copy of your probation violation arraignment advice of right sheet?
Yeah, like 2 days ago.
Did you read that document?
Yeah.
Did you understand those rights?
Yeah.
Okay. So this this probation violation warrant that I have reads as follows: that you were placed on probation to the court for the felony offense of possession of narcotic or cocaine less than 25 grams with the double drug enhancement. This is a felony which carries up to 8 years in prison. You understand that?
Yeah.
All right. Count 1 and count 2, both allege a violation of condition number 2.4 that you not use or possess any controlled substances. The allegation is that on or about August 2nd, 2023, you violated that condition by testing positive for and admitting to use a narcotic, and you were also found in possession of oxycodone. You understand the allegations contained in count 1 and count 2?
Yeah.
Count 3 alleges that you violated condition number 4.19 when on or about August 2nd, 2023, you had contact with felon Samantha Bellinger, and you did not have probation from your field agent. Do you understand the allegations contained in count 3?
Yes.
Counts 4, 5, 6, and 7 all allege a violation of condition number 1, that you not violate any criminal law of any unit of government. They all are alleged to have occurred on August 2nd, 2023. Count 4 says that you violated the law when you were found in possession of oxycodone. Count 5 says that you violated Michigan state law when you gave police false information. Count 6 says that you violated the law when you drove a motor vehicle without a valid license. And count number 7 says that you violated the criminal law when you used a controlled substance narcotic. To understand the allegations raised in counts 4, 5, 6, and 7.
Yes.
All right, count 8. 8, 9, 10, 11, and 12 all again alleged violations of condition number 1, that you not violate any criminal law of any unit of government. Count 8 alleges on or about August 2nd, 2023, that you violated Michigan state law when you stole belongings, stole items belonging to Dolores Jarvis. You understand the allegations contained in count 8.
Yeah.
All right. Counts 9, 10, 11, and 12, all again alleged violation of condition number 1. They are all alleged to have occurred on December 19th, 2023. Count 9 says that you operated a motor vehicle without a valid license. Count 10 says that you violated the law when you fled and you tried to flee and elude police officers. Count 11 says that you violated state law when you assaulted or resisted or obstructed police officers. And count 12 says that you violated Michigan state law when you damaged a Macomb County Sheriff's vehicle. To understand the allegations contained in 8, 9, 10, 11, and 12.
Yes.
Oh boy, that sounds like a heck of a flee and elude. And by the way, Gardening LSB, if you're still awake when you get to this point, remember that I love you and thank you for being here. I know you went to lurk mode and I just had to throw that in.
All right, 13 alleges that you violated condition number 3, which required you to report to probation as directed. The allegation is that you didn't report on August 9th, 2023. Do you understand the allegations contained in count 13?
Yes.
All right, counts 14 and 15 are both allegations that you violated condition number 2.4, that you not use or possess any controlled substances. They both deal with December 19th, 2023. Count 14 says that you were found in possession of methamphetamine. And count 15 says that you were found in possession of cocaine. To understand the allegations raised in counts 13, 14, and 15. All right, count 16 says that you again violated condition number 2.4, December 19th, when you were found in possession of drug paraphernalia. To understand the allegations contained in count 16.
No, because I wasn't found in possession of any drug paraphernalia. Yes,
Well,
yes.
So I'm not asking whether you agree with it or not, I'm just understanding that's what they're accusing you of.
Yes.
All right. Count 17, violation of condition number 4.18, that prohibits you from engaging in any assaultive or threatening or intimidating behavior. The allegation is that you engaged in that behavior December 19th, 2023 with Jessica Patrick. To understand the allegations contained in count 17.
Nope, I don't understand those ones at all because there was no charges or anything like that, even close. I don't. I mean, yeah, I guess I understand the allegation of the probation violation, yeah, but I don't. Yeah, I don't know what that is about. But
okay, so counts 18 and 19 are again another violation of condition 4.18. Both are alleged to have occurred on December 19th, 2023. In that case, in count 18, you're alleged to have made threatening or intimidating statements to McLaren Mount Clemens Macomb Hospital staff. You understand the allegations contained in count 18?
Yeah.
All right, count 19, same date, that you made threatening or intimidating statements to MCU officers. Understand the allegations contained in count 19?
Yeah. I
All
sure.
right, and then count 20 is it violated that is an allegation that you violated condition 4.12, that you must not own, use, or have in your control a weapon of any type. The allegation is that on or about December 19th, 2023, that you were in possession of a pocket knife. You understand the allegations contained in count 20?
Yeah.
All right. And Ms. Frisbee, what plea does he wish to enter?
Well, not guilty at this time, Your Honor.
All right. We'll enter a not guilty plea for Mr. Roney. And Mr. Roney, did you plan on hiring an attorney in this case?
I have no idea. I don't know what's even like half of these. I have no idea. Half of that allegations I've never even heard of. So like, yeah, I guess I don't know. I have a court appointed attorney for the cases that I'm dealing with now, but I don't know. I was a month away from being done with probation. I have no idea what all this is about.
You
Honestly.
done fucked up.
Do you wish to be represented by an attorney?
Yeah.
All right. How long have you been locked up, sir?
Since December 19th.
Oh, so you'd have been off of probation by now if you hadn't decided to go on a bender and do all kinds of substances and then take it out on the police and the hospital staff. You'd have been off probation by now. You'd be starting a whole new set of charges at this point, but it probably would have made everything a lot better for you to be off of probation and starting new charges than it's going to be now to be violating the probation plus now going into these charges. You just couldn't make it that one more month. Not that I think you didn't do all of those things and just not get caught through the 2 years that you were on probation. No, I'm not going to believe that for a second. You weren't some choir boy for that time. Billy doesn't believe you either.
All right. Do you have any money saved up?
Right now, no. I've spent it all on this and attorneys. No, I've been locked up since December 19th and I haven't been able to go to work. So, yeah.
All right. So the court will appoint Attorney John Greer to represent you in this case. The next thing we need to do is to set a bond. And Mr. Roney, I don't want to know anything about these allegations because we'd entered a not guilty plea to them. But is there anything else about your personal circumstances that you want the court to consider in setting a bond?
Well, I'm already I'm incarcerated right now. There's no way I'm gonna be able to post a bond. So I don't know. And not at the moment, I'm not gonna be able to post a bond. So I don't know.
Okay.
I guess.
Mr. Musman, anything that you want the court to consider?
I can enlighten the court here on what's going on with it at the moment here, which pertain to the bond here as well. He currently has 2 cases pending in St. Clair County there. One case he has 4 felony charges there. The other case he has 1 felony charge, which is for looting, controlled substance, and assault and resisting obstruct police, and as well as unlawful use of a motor vehicle.
I'm shocked.
One case he has a $50,000 bond. The other one he has a $10,000 bond, both being cash surety.
Say it ain't so.
He originally, when he was sentenced here, he was instructed to report to the jail and serve 12 months. He failed to report. Once he was lodged, served his 12 months, he ended up being released early from jail after serving 242 days. He wasn't on probation very long when he absconded and began to fail to report. And he currently has 7 other outstanding bench warrants waiting for him to
Do you know his next court date on those other felony cases?
Let's see. He already had his PCC hearings. He has his exam hearing on today at 10 a.m. The other one was supposed to be tomorrow, January 10th at 9:30 a.m.
They've all been rescheduled for next week.
Okay, thank you, sir. Ms. Robinson, anything that you want the court to consider?
Nothing beyond the agent already indicated, Your Honor.
All right, the court's going to set a bond at $50,000 cash or surety. In this case, we'll set this case for a probation violation hearing February 26th at 2:30. The court's not scheduling this hearing within 14 days because you have new pending charges that are just working their way through the system. Those pending charges also dovetail into these allegations. So the court is not required to set the hearing within 14 days. So we'll set it for February 26th at 2:30. And we'll let Mr. Greer know that you're currently incarcerated in St. Clair and make attempts to contact you. Some counties are easier to set up meetings by Zoom, and some of them are really, really difficult. But we'll let him know where you are, and he'll do his best to contact you before the probation violation hearing.
So he's not even in the county that they're arraigning him on the charges of. He's locked up in another county for other felony charges and getting read his charges in Newaygo County because he's been a bad boy all over the place.
That's all for today.
What day is that, Phil? Oh, Lisa May, what day is that? Don't make me go back and rewatch that part of the clip to find it. Please. Oh, you guys, thank you for coming out. I'm sorry if I wasn't as fun and perky and peppy as usual. Thank you. It's only a couple weeks after my daughter's birthday, and she turns 18 this year. So we'll probably still be celebrating. But, yeah, I am going to go to sleep. I love you all so much. And I am so grateful. Oh, yeah. Yeah. Oh, wait. I meant to click on Stephanie's comment and talk on it, and then it jumped. But that's okay. I got Shane instead, and Shane's cool shit. 18. Yeah. My baby girl. My one and only perfect little angel. And she's turning 18 on me. And then she's going off to college. And I'll get my house back to myself with just the animals. It'll be good times. I did promise to her that I would leave a room for her. So if I get a new house, or as I'm, cleaning and sorting and organizing this one, there has to stay a spot for her and her stuff. I won't get rid of her stuff until she actually gets her own apartment, apparently. It's okay. I love the brat. She's a great kid. And I love all of you. Every one of you. Thank you. At least it don't sound like mine. Hopefully, next time will be tonight. Hopefully. With any luck, I'm over the worst of it, and I'll be able to be here. I'd much rather be here. And the cats much rather I'm here. Man, they were not okay. They were in the bathroom with me, meowing very excessively loud. They did not know what was going on, and whatever it was, they did not like it. But my babies. The perfect paw firm. I know. I've got a traffic docket from someplace I've never heard of before. I've got one of those ready. I didn't do filler clips in between, but that one I had to chop up and then rearrange parts because there was a lot of, I'm gonna put this on hold and take a couple more cases and then I'll bring you back in. So to make things, flow in a way we could follow them, I chopped each clip up that I was keeping, deleted the ones that, weren't any fun or didn't have any info or, nothing special happened. And then the ones that had gotten set aside and then brought back, I would then go and, get the second half of it and connect it to the first. So it's, it's still a little choppy-ish looking, but it makes more sense because the parts are together. Oh well, it is what it is. When they want to sit in a bathroom with me for 6 hours, they're gonna see stuff. I know, that's one of my favorite things. Don't you... What are you... Ava, you're gonna have to move. Ava, go lay down. Y'all, look at Billy. I love it when they get zoomies too. I don't love it when they get the, I'm going to zoomy zoom under the bed. I'm not a fan of this. Billy, can you stop with the kicker on my bed? Billy, wipe that face. Wipe that look off that face. Come on. You've got the jerk face right now. Give me my sweet Billy back. Give me my sweet Billy back. Let go of my bed, dude. Let go of the bed, please. The whole world is looking at you right now. Well, the whole world that matters. My chat. Billy, come on, dude. Come on. See, be good like Earl. Of course, Earl does that too. He started it, actually. Come on, Spider Cat. Come on. Oh, you're just gonna sleep there now to spite me. I see those eyes getting all droopy, just like Mama's. Oh, you're too darn cute. All right. I can't meow. My mouth is too dry. I'm semi-dehydrated from being sick for 2 days. So I would meow at him if I could, but I can't. Good bite. I love you, Philip Heels. Thank you, Shane. I love you too. I got it right here. the caffeine-free, bean-free coffee. You trying to say something? Good night. I love you all. Be safe. Be well. God. Be safe, be well, sleep sweet, and much love.